Yeah, I welcome you all to the today's VCM, which will be deliberated by CA Vinod Jain sir. I'll just display the profile of with CA Vinod Jain sir. Then after, Chairman sir will take up for the opening remarks.
Okay, friends. So
now I just want to clear one thing, that the session will be of 3 hours and it will be divided into two sessions, 1.5 hour one session. After that, a break for 5 to 7 minutes, and then sir will take up the another session. So
yeah,
over to you, Chairman sir.
thank you. Good afternoon, friends, and I welcome learned speaker CA Vinod Jain, who had been on the council of our institute. Along with me, we have Vice Chairman of Direct Taxation Committee, CA Dr. Raj Chawla. He has coordinated this particular program, so I appreciate the support which is given by Vice Chairman in arranging this particular lecture. As we are aware that nowadays people are more engrossed in corporates, in LLPs and mergers, acquisitions, and so many things. But then at times we gloss over the traditional matters like HUFs and partnerships. Therefore, it is necessary that we have to reorient ourselves from on these topics as well, because from the taxation, these topics also assume great importance. And maybe today's topic, like Hindu undivided family, it also helps in planning your taxes, in addressing your wealth issues, and there are various other matters. So it has been the speaker will explain us. So it is very important that we understand this concept of HUF, how it is constituted, as we loosely call. Whether the word constituted is also appropriate or not is a question mark. So all these aspects need to be addressed. In fact, members will recollect, those who are viewers, that last year Direct Taxation Committee has brought about one booklet on taxation of Hindu undivided families, and that is also available on the website of DTC. So anything further you require can also be seen in that particular booklet. But then there may be certain issues which may be in your mind about the HUF, about the partition, about partial partition, about total partition, and so on. And to understand those issues and really bring home the custom-made law, the judge-made law, and this particular behalf, we have requested CA Vinod Jain to enlighten the members in this particular behalf. And this is the first program for Direct Taxation Committee. So, like for India, Sachin Tendulkar used to open the innings. I think for us, that DTC Vinod Jain is our Sachin Tendulkar, and I'm sure with this particular presentation, the DTC will certainly score a century. With these opening remarks, now let me invite you, Vinod Bhai, to address the audience.
Thank you very much, Shri Chandrasekhar V. Chitale ji, Shri Raj Chawla ji, both being chairman, respective chairman and vice chairman of Direct Tax Committee of the Institute of Chartered Accountants of India. My and learned Central Council members, both of you, and I think Chitale ji was even managing Direct Tax Committee last year, and I have seen the manner in which Direct Tax Committee was led by Mr. Chitale has been, of course, has added great value to all of us. Now, sir, in today's conference, we are trying to, I will be assisted by my colleagues, Advocate Ananya Madhusudan and Advocate Akhilesh. Both of them will also be part and parcel of my team, who will be actually who have been supported me in preparing the presentation and also will support me in presenting the whole thing to you. We'll try and go through the entire gamut of the law. I think the first part, as Chitalaji has rightly said, we'll be talking of the succession law of the country, including the HUF part, ancestral property, self-acquired property, because it become a very mixed question of what is ancestral property, what is self-acquired property, what is HUF property, because there are different manner in which they will get inheritance will happen, and a very large number of disputes. To my knowledge, about 30 to 40% disputes in all leading courts, the civil disputes, are related to property settlements. And a majority of them are primarily coming to the courts because lack of understanding on the part of most of the people on one side, and improper planning by the people who are owners, who are currently owners of the property. And in a very large number of cases, we have seen people even lose their ownership and control of the property also. Although that part, how do we really take care of you, we'll try and really indicate wherever possible. But our concentration will be primarily on the inheritance law, so that one can really understand. You start your life with a small money in your hand. Slowly you work hard and create a small business, then a medium-sized business, then a large business, and create large properties for yourself, create large businesses for you and for your successors. But whether the succession of your business on the one hand, similarly succession of your personal properties, your shareholdings and the things like, whether it is happening in the right direction, whether the properties, immovable properties and movable properties owned by you go to the right people or not, it is a very, very difficult question of law. And I think we are going to really take you through the entire gamut. How do you really plan it? Because I've seen it is primarily taxation experts, being chartered accountants, commanding about 90-95% shares of the tax practice and tax advisory services to all individuals, corporate, private sector, and even public sector. It becomes very important for us as chartered accountants to understand this law a little deeper. I know broadly all chartered accountants are aware of how the succession is happening. But when you know it broadly, sometimes it may not be appropriate for us to advise our clients. And secondly, for taxation experts, now of course this is an additional area of practice I will see, because now most of us are not required to go to the tax offices to really appear before the assessing officers. So we can also actually manage and advise our clients on the niceties of the preparation of will or preparation or creation of a trust, and also other parts of the succession planning. And then these tools of trust, whether it is a domestic trust or an international trust, can be used, very significantly used for tax planning purposes, and beside that several other purposes. Similarly, HUF as a tool, as we are aware, HUF is a separate legal entity, not legal entity, it is a separate tax entity. And it is assessed separately, like you have, if you are two people in the family, three people in the family, HUF become a fourth person. And you have one more individual in your family to get assessed separately. And I think all deductions and all advantages which an individual is entitled to, similarly are available to the Hindu undivided family also. I think I am not going into the details of the tax aspects, because we have experts like Mr. Chitale, Mr. Raj Chawla, and there are several tax experts all across the country to really explain to us the implications of taxation. But I think before we understand the implications of taxation, it becomes very, very important for us to actually understand and appreciate the real how really the assets will pass on hands from one person to another, and how do we actually monitor the whole thing, and how the businesses also should be really planned for how the businesses can be planned for succession. I think although today the business succession planning, business succession will not be dealt with today, because that is a subject in itself. I think we have about 3 to 4 hours minimum session on to planning how a family business need to be succeeded, when there are a smaller family, when there is a large family, and then when there are very large families. And then there are different models. We call them Goenka model, we call them, you can say, as the Birla model, and maybe sometime we call them at Ambani models of where everything is mixed up. There are many models which we talk about it. But today we'll be only very broadly touching it, because we have a very huge subject in our hand. and let us see. We have about 3 hours in hand, and out of which already 12 minutes we have already really spent on this introductory part. I'll request my colleague Ananya to actually take it to our presentation so that we can go step by step on various aspects of this portion. While presenting it to you, I'll also be presenting to you various case laws of the Honorable Supreme Court and various high courts, how they have interpreted various aspects, and I think that will help you substantially in managing the affairs of your client in the right direction in advising them appropriately. So if you can go to full screen mode, that will be better, Ananya ji.
And in the meanwhile, I will also request the viewers that if you have any queries, you may please mail to dtc@ici.in so that maybe we can subsequently ask these queries to the speaker. Thank you.
So thank you very much. I think we'll be answering all queries, and more queries are welcome, because through the queries portion, one is able to clarify as to what is being done and how practically issues are there and how those practical issues are actually to be handled. Because while narrating the theory, I'll be also sharing my practical experience along with my colleagues Ananya, Madhusudan, and Advocate Akhilesh. I think all of us will try and really put forth before you our viewpoint. So Ananya, can you make it full screen, please? Just please share the screen and go to this slideshow so it become larger. Shrutika, can you guide her on through this modem how to become full screen?
Just maximize the window, no? She has not maximized the window, I guess. Or just zoom the. It's maximized.
Yeah, it's already maximized. There is some technical glitch, I think.
Yash, can we send this PPT to you? Can you share? Hello? Can you help them out, or can you share the PPT if we send it to you? They are not able to make it full screen.
Okay. First full screen, then share. Ananya, first full screen, then share. Ananya ji.
Down right corner.
No. It is coming only this large. Can it become larger? भेज दो फिर भेज दो अपने ट्राई करते रहते हैं
दिख रहा है बट मैम ये ना आई मीन इट विल कट डाउन
I cut actually presentation. We are sending you a copy of the presentation to the DTC. Ananya, in the meanwhile, दिखाते रहो, शुरू तो करते हैं. We will not waste our time. We will continue with in whatever shape it is we are able to show it. And then simultaneously you can send it. Yes, I think I'll continue in the meanwhile so that, while they're sending it, it can become larger, nothing like it. So, so today our scope or presentation of the first session will be...
It's properly visible. This side is also properly visible.
It is okay with you now?
Yes, sir, yes.
I think but then it is okay. I think to me also it is now better visible. It is perfectly fine. And then we can commence like this. There is no problem. Okay. So now, the scope of presentation will be need and importance of succession planning, personal succession planning process, because as I told you in the initial remarks that business succession planning is a very big subject in itself. I'll be only introducing that part but will not deal in detail. Then succession planning, what are the goals, what are the questions, what are the steps which are required to be taken. Then introduction of key inheritance laws, its applicability, the scope of Hindu succession law. Then I think we'll come to the complex portion of succession of HUF property, ancestral properties, self-acquired property, joint family property and co-parsonary property. Right of daughters, conversions and rights of illegitimate children, adverse possession, defective title, power attorney and spec successions, etc. So this is the broad portion of the session 1. And then in the session 2 we'll deal of course with the advanced aspects of succession planning, which is testate succession planning. This will be interstate part, and then I think we'll go to the testate. Testate means something which you can actually decide on your own based on the Indian Succession Act and various other laws. So we go to the next slide, Ananya ji. You see, Benjamin Franklin said in this word, nothing can be said to be certain except death and taxes. So I think as a direct tax committee we are aware, taxes are certain, we are bound to pay, and death is also certain. But most of us do not plan for the death, and it has to come to everyone. But everybody keeps on watching. No, it is far away as far as I am concerned. That is how we have to suffer very significantly. Some of the key reasons why it is important to undertake succession planning, of course, first and foremost, most important is avoiding family dispute. Family dispute happens in almost every second family, but the well-known we have seen as Ranbaxy, Ambanis, Singhanias, Apollo Tyres, we have seen all these families one after another getting into various kind of dispute with each other and thereby impacting their businesses as well as their personal life. So from the personal perspective, if you see, it is important to ensure proper provision of cash flow and look after the self for the, there could be an illness to yourself. You could yourself become incapacitated. So that is first part. When I am talking of succession planning, because now the life expectancy has really gone up, so it is possible that during the advanced stage of your life, you get into the severe illness, or you may become even incapacitated to really take decisions. So it is important to plan from that personal perspective. Then you need to also ensure accommodation, the funding of basic expenditure, maintenance, etc. Allocation of specific assets to relevant successor is the next part. So I think first is you need to provide for your own accommodation, funding basic expenses. Suppose you become illness or incapacitated or old age. Then of course relevant successors, and then devolution of property should not happen to unintended beneficiaries. आप जिसको नहीं चाहते हैं उसको प्रॉपर्टी नहीं मिलनी चाहिए, जिसको चाहते हैं प्रॉपर्टी उसी के पास जाए. I think that is a very, very important portion. Then disproportionate distribution of assets if you want to do. We are aware that in case of interstate succession, everything go as per rule of law. And suppose you don't want to actually do it as per rule of law, and if you want to distribute your properties after your death to different successors in different proportion, then of course you need to definitely plan it. Now, I think the last and very, very, very important portion is ensuring proper provision for your spouse, your children, and most importantly, the parents, including special care and regular cash flows to them. Your own parents, your own spouse, your own child, they will get very severely impacted if you are not really done succession planning properly. You may be having a lot of properties, but they'll really get stuck up here and there. I think as we go further, we'll really explain you how they get really stuck, and it doesn't go to the right person at the right time when they really need it. So it is very important for every single citizen of this country, every one of our clients to actually understand how to take care of succession planning. Go to the next, please. Now, just a broad introduction of business succession, the business perspective. Succession in family business, how do you succeed the ownership, and how the management is, there is a succession of management. From one generation to another, how the ownership should transfer and how the management will transfer. Now, of course, there is a possibility of instability in control over companies owned by the family. somebody is owning 10%, somebody is owning 5%, somebody is owning 30%, somebody is owning 0.5%. So how this whole thing will get actually, suppose the 35% person dies tomorrow, then what will happen? Who will control the company? Ensuring continuity of family business is, of course, very, very important for success and growth of everybody. One need to identify the role of next generation, and of course, how the businesses, existing business and new businesses will be run, how the family brands will be used, who will use it, who will be entitled to use the family brands, under what conditions, and of course, whether the family members will have a right to liquidate their shareholding in the main companies or the operating companies or even the investment holding companies, or that will also be monitored by succession planning. And it might be important to ring fence certain properties from creditors and from various other people. You might have given your personal guarantees to the bankers or to the lenders, and you want to ring fence at least certain properties, maybe property in which you are living and some other important properties for a family, so that they are not high and dry because of the problems which may come arising out of the insolvency or various other personal guarantees and attachment proceedings and various other proceedings in the surface eye, etc. We go to the next, please. No, we are still on the overall concept of business perspective. Yeah, that's right. So succession planning is a formalized process to successfully transfer company leadership. We are talking business right now, from current management to successor management. It is designed to ensure ongoing viability of the company. So this particular 2 slides, one slide I have already talked. The second slide is primarily to give only an introduction as to how business succession is also very, very important. And I'm sure we'll have another chance of going to the niceties of each and every aspect in a very, very detailed manner. We have a very detailed presentation, but that will also take about 3 to 4 hours. So I'll be only touching upon it. So the process of management succession will be what, and process of ownership succession will be what is primarily which is required to be done. The activities which we really undertake, normally as a chartered accountant, you can help the families concerned to create a family charter. It is like a constitution. It determines what you can do, what you cannot do in the family, on the personal front as well as on the business front. Then I think as a part of family charter, there is a background noise. Shrutika ji, just check, huh? So, there is a business rules in the family which are also part of the family charter. This also determines the family ethics and family culture. What are the minimum ethics which a family members are going to really follow? What is the family culture which is binding on the family members? And then it provides very importantly for business meetings of the family to take important decisions. And then of course there is a family council which gets created. The difference between family meeting and family council is family councils consist of primarily people who are day-to-day managing businesses, who are the major decision makers. Whereas in an overall family meeting, you invite every single member of the family, of course barring very, very young children, you invite everybody, ladies, gents, everybody, and wherever the various decisions are taken, and more importantly where the communication is done between family members of what is being planned, in which direction we are going. And of course the most important part in management succession is one need to groom successors, and of course management process also one need to determine. The ownership succession comes out of course family communication, as I told you, the family charter, rules, culture, meetings and council meetings. But of course family governance is determined through that process, and there could be a shareholders agreement which might be required even among family members, so that whether the shares are transferable, whether there will be right of first refusal, and whether somebody can transfer outside the family or not. I think all those issues can be really handled through shareholders agreement. What are the desired outcome? The main desired outcome, of course, is integrated family members. They are given various options based on assessment which is done, and decision making is informed, and everybody can be provided the comfort level to the extent it is possible. We can go to the next slide, Nanaji. Now, I think we'll start with the process of personal succession planning. How do you actually do the personal succession planning? And this exercise, we call it, actually it starts from the 3 important aspects. We call it love, money and control. An appropriate balance of love, money and control is primarily the entire exercise of personal succession planning. You have money, you love the people around you, and of course, but you definitely want an appropriate control, and that succession should happen in a controlled manner, so that the people to whom you want to provide that benefit, that goes to those people only. So before you actually do we'll go step by step how to go about it. The first and foremost step is identify your own specific goals. What is your goal of succession planning? आप succession planning क्यों करना चाहते हैं, क्या achieve करना चाहते हैं? You can possibly retain an advisor, a chartered accountant, or a lawyer, or a chartered accountant and a lawyer who are actually expert, or maybe who may not be expert but who are close to you, who are able to guide you, and they can of course take necessary assistance from experts. So you need an advisor to determine the best strategy to achieve your goals. Ultimately people and their goal are different. Everyone is different. Mr. A, Mr. B, Mr. C. Mr. Chawla is different from Mr. Chawla. Mr. Chawla is different from Vinod Jain. And Vinod Jain is different from Ananya and Akhilesh. And Shrutika is of course entirely different. So everybody, people are different, their goals are different. And circumstances of each one of us is different. So accordingly, the strategy of succession planning and the need of succession planning, the process, everything need to be very, very carefully crafted. It has to be tailor-made. You can't have a straight jacket approach. Okay, no, we prepare a will like this standard will, and accordingly you go ahead and really do it. The succession planning is not a process which can be done by machine. It is full of love, money and control, as I told you. It is an emotional process. We go to the next, please. How do we determine, somebody will ask me a question, how do I determine what is my goal? How do I begin with the estate planning process, and who can help me developing my estate plan? These are the questions which comes to mind of each one of your client, and maybe of course to your mind, because I think chartered accountants for themselves also can do succession planning. They can do for others. They can do for everybody around the system. We can go to the next. So I think to start with, for determining the goal, you need to plan your goal. So one need to really search his heart. What is in your heart? Not really what you have made notes of. तो आपने जो लिख के लाए हैं कंसल्टेंट से डिस्कस करने के लिए, that before that what is important is ये दिल क्या चाहता है? What is your heart saying? कि भाई किसको क्या देना है, क्या करना है, कैसे करना है? ये अल्टीमेट डिसीजन सिर्फ माइंड से नहीं होता है, दिल से होता है. So it has to be done along with mind. The major role is played by your heart. So your heart will tell you what is your goal. आप किसको look after करना चाहते हैं? सबसे पहले of course आप अपने आप को look after करना चाहते हैं. Maybe then here comes your parents, then comes your wife, and sometimes maybe your children, and sometimes maybe even a third party who is more close to you. So that depends on how do you really want to do it. And circumstances, I told you, is different for different people. We can go to the next, please. So the first goal could be planning for loved ones, as I said, to provide for the family. What is important for them? How to act to take care of disabled or heirs of deceased family members. So one is the current family members, and then there could be deceased family members whose legal heirs are there. Some people might be disabled, some people might be different abled. So you might have to actually plan a very, very important manner. तो ठीक से पहले गोल बनाइए कि हमने फैमिली को लुक आफ्टर करना है, डिसेबल्ड को करना है, हियर्स ऑफ डिसीज फैमिली मेंबर्स को करना है, किस किस को करना है उसको देखिए. वी गो टू द नेक्स्ट गोल. Now, the next very important goal of a succession plan is you need to plan to pass on your legacy. This part is very, very important. It is not only an exercise of transferring your wealth. It is a question of passing on the family values and family beliefs. For that purpose, it might be very, very important for you to actually document your family history and share that family history with your successors. I would suggest each one of our listeners to definitely try and really understand the family history from their parents and from their grandparents, and also pass it to the next generation, because that will only bind the entire family to family traditions and family culture. हमारी फैमिली में तो ऐसा नहीं होता, हमारी फैमिली में वैसा नहीं होता, खाली कहने से नहीं चलेगा. I think we might have to actually tell them that we have been following this, and that is how it has really helped us over the centuries. Our family is together, and our family culture is accordingly decided actually. So then a well-documented personal family history for communicating to children and grandchildren is certainly a meaningful estate plan. So maybe as a chartered accountant, you can help writing family history for your client, or maybe you can retain somebody, just guide him, he'll write a very good family history, and also what is the family values, what are the family beliefs. And then once you document it, it becomes a very, very important part to really tell everybody. But till the time you are able to document it, it is very important to communicate. And before you communicate, it is very important to take from your parents, from your grandparents, as to what are the family values and beliefs about which our family is known, or for which we have to be actually committed. What is my family history? What is my family tradition? What is my family culture? Otherwise, passing on asset, वो कहते हैं पूत कपूत तो क्यों धन संचय, पूत सपूत तो क्यों धन संचय. हमारे यहाँ कहा जाता है, क्यों कहते हैं कि unless you are able to actually pass on your wealth along with your family values and belief, the entire wealth may really go waste. And it may be actually, you might have really earned it, working very hard, making every, saving every single penny, investing it carefully, but it may be wasted by your successors unless they know what is the importance of how, with what great difficulty it was earned, and how important it is to actually sustain it. Because sustainable growth of family values, family belief, and family wealth, all three are together, which is very, very important. Now, next is you want to plan to avoid probate and intestacy. We are aware that if there is an interstate death, then there could be a lot of issues, and sometimes your assets may go to some unintended people, and you want to avoid a probate. You don't want to go to a court and take a probate, so that could be another goal you have. And in any case, everybody has a goal to plan to minimize taxes. If you plan your will or your succession plan properly, you can surely do very significant work to reduce your taxes. And I think how, of course, there are a lot of tax experts around us, they can tell us. Even in the Income Tax Act, we'll find at several places there are special exceptions to something which is done by a will. And a trust created by a will is given different tax treatment, or a gift which is done under Section 56 through a will is also given a different treatment. And there are n number of sections and n number of judgments through which you will really be able to really understand how to minimize your taxes. And of course, we are going to share with you with some tips about this also, minimization of taxes nationally and internationally, how really it can be done. You can plan for your own or spouse or children or parents' disability. देखिए, खुद की डिसेबिलिटी हो सकती है, स्पाउस को और चिल्ड्रन के लिए कर सकते हैं, या फिर पेरेंट की डिसेबिलिटी हो सकती है, सबके लिए. दैट इज द फिफ्थ गोल विच यू कैन हैव. नेक्स्ट प्लीज. Ananya ji, can we go to the next? Yeah. As I told you, tax we'll discuss detail in some future presentations. Of course, it is not the subject matter today, but of course, we'll be only touching the taxation part of it, definitely, because I'm aware that I'm among the tax experts. So, we'll be definitely touching certain portions, but to the limited extent possible. Now, how do you do succession planning? What are the steps? So, the first and foremost step for anybody is to list your assets and liabilities, present and potential future. It is important to list out all assets one owns before commencing the succession planning exercise. क्या चीज का ध्यान रखना है? What are the all important consideration is whether the asset is wholly owned or jointly owned with other people, whether the person is the legal owner of the property sought to be bequeathed, or it is only the possession which you have, or you only have a power of attorney holder. If the person is a member of HUF, whether the asset intended to be bequeathed is a HUF property or a self-acquired property, or is it an ancestral property? It becomes very, very different to plan it for ancestral property differently, HUF property differently, and of course self-acquired property, of course, you have very, very different rights. Your rights are different, as I am going to explain you. What you can really pass it on a will is only what you have. So what you don't have, you can't really. There are a lot of restrictions on what you can bequeath as a part of HUF property or ancestral property. I think we'll let us see. And if you're a trustee, you might be a trustee. You may be having huge assets held by the trust. Whether the property intended to be bequeathed is a self-acquired property. And of course, as a trustee, how do you really transfer from one generation to another the assets which the trust? It could be a private trust, it could be charitable trust, but still you want to actually ensure that it goes to your successors. How do you really plan it? What is the location of asset, whether it is within India, whether it is in Singapore, whether it is in the US, whether it is in Africa, or whether it is in UK. I think that all will determine. And what is the nature of the asset? Nature, I think we'll discuss the nature of asset also, where the asset could be movable assets, it could be immovable assets, it could be shares, it could be jewelry, it could be paintings, it could be right to receive certain things, it could be intangible assets, it could be patents, it could be copyright. So there are different assets which you may have. So you need to list out and then list out their attributes, and accordingly the plan has to be done. Then what is required in succession planning is to determine the beneficiaries and determine the fiduciaries. So beneficiaries are the people to whom you are going to really pass on your wealth, who are going to be your primary beneficiary, who are going to be beneficiaries thereafter, or maybe the ultimate beneficiaries. I think that is what you can really plan. But to enable you to actually pass on this to your beneficiaries, you also have to determine the fiduciaries very, very effectively. And how do you determine the fiduciary? Fiduciary, what is the fiduciary relationship which is required here? The fiduciary relationship required here is, the executors. Sometimes you may be requiring, you have to definitely appoint, once you, of course, prepare a will, that who will execute the will. Mr. A, you appoint, he will execute your will. And suppose Mr. A himself become incapacitated, whether Mr. A is actually trustworthy also you need to determine. Whether Mr. A will survive after you, or he might have also gone away. So what is going to be the alternative fiduciary? I think various thoughts which might have to really go. Considerable thought must have to go in the selection of fiduciary and beneficiary. It is difficult, and of course ultimately your heart is going to really come to your help. Your heart is the king, and confidentiality is the key. You need to keep the entire exercise confidential to the best of your ability, because if it becomes known, it may bring several problems. But how do you actually, certain portion you need to actually communicate to whom? To people in whom you have trust, and to what extent you want to actually disclose to them. All that we'll discuss as we go further. We go to the next, please.
So
Following are the main succession planning tool, of course. Will. A will, of course, we'll be discussing in the next session in greater detail how to prepare a will. And trust also we'll be talking in very, very great detail in the next session. A will actually set forth, the testator means you, whose wealth we are talking about, and their wishes regarding distribution of his or her property, and take care of descendants, next of kin. Properties under will can be directly bequeathed or bequeathed through a testamentary trust to the concerned legatee. आप directly भी दे सकते हैं, through a trust भी दे सकते हैं. It is possible that there are young children, they cannot manage themselves, so you appoint trustees through your will, and those that it can be managed through trust. Or sometimes, there are ladies who may not be able to really manage themselves, or there could be even males who may not be able to look after themselves properly. So you definitely want to create a structure like a trust who can take care of them as beneficiaries. That also through a will you can do. A trust you can create while you are living, or a trust you can create through your will. There are several ways. A trust is a fiduciary relationship between the settlor and the trustee. This I think we'll discuss in detail. And what kind of it could be revocable, irrevocable, it could be discretionary, it could be specific. And accordingly the taxation aspect will be decided. We are aware that in case of a revocable trust, the income from a trust get clubbed in the hands of the person who has actually set up the trust, the settler who has transferred the asset. Whereas that may not happen in case of an irrevocable trust. And in case of a discretionary trust, we are aware that everything is assessed in the hands of the trust, and if the discretionary trust is running a business, then of course it is taxed at the maximum marginal rate. But in case of a determinate trust, the trust is assessed as if the beneficiary is going to be assessed. Determinate is a specific trust. So in that case, suppose there are 3 beneficiaries, 33% each, then the entire income gets divided into 3 portions, and it gets assessed in the hands of either the beneficiaries or in the hands of the trust, as if it would have been assessed in the hands of the beneficiaries. तो assessment में होगा अलग अलग beneficiary के हाथ में ही, उसके हिसाब से ही, या तो beneficiary, it might be taxed in the hands of the beneficiary, or it might be taxed in the hands of the trust, because sometimes the income tax officer has been given that option that in case you are not sure whether you will be able to actually recover money from such a large number of beneficiaries, then you want to actually, even if the trust is determinate, you want to recover the tax from the trustee, and trustee will ensure that he provide details of every single beneficiary and get his assessed beneficiary wise. I mean, somebody may get 20%, somebody get 5%, somebody get 40%, and accordingly it will get taxed, and with the benefit of respective slabs to respective beneficiaries also is given, and it is added to their existing income, any other income which they have other than the income coming from the trust, and accordingly it is done. Accordingly, it is taxed in the hands of the trust, the combined as a whole. For 5 persons, 5 people, different, there are 5 computations, then they are clubbed together, and the tax is paid by the trust. And then, of course, once the tax is paid by the trust, then it is again not taxable in the hands of the beneficiaries. There is no double taxation in case of a trust. So there are certain other associated constructs of succession planning. Of course, we have talked about family constitution. This is a document which typically set out the rules for transition of family business. From one generation to next, it recognizes family tree, family values. देखिए family tree भी बड़ा important है बनाना अपनी family का. Family values, family objectives, roles and responsibilities of different people, business relationships, and certain do's and do nots. For example, we have seen certain families may say that if anybody who marry into a different religion will not be really entitled to any wealth, any portion of the wealth. It could be a family constitution, and it might be coming from one generation to another. It is possible that the current generation do not want to follow, but then in that case, family constitution with the support of each member of the family might have to really be revisited. Family offices is a concept where it manages multiple businesses and investment of a single family on a day-to-day basis. Not necessarily because the KMP of the main companies, the CFO and CEOs have no interest in managing the shareholding or the wealth of the family. That portion has to be done by the family members with the help and support of a family office. And here also chartered accountants and especially tax experts can play a very, very important role. Internationally, we have seen it, whether it is in US or in UK or in various other parts of the world, even in Singapore. We have seen it where we have actually been interacting with large number of business families. There, of course, this whole portion is being looked after primarily with large attorneys and advocate firms. But in India, typically the businessman and the taxpayers, they find themselves maybe more comfortable dealing with their own tax advisor. Of course, as a tax advisor, you can always take help and support of appropriate legal professionals so that actually you provide a right solution. Maybe in your family office, you can have either a full-time or a retained advocates to help and support it. So even as a chartered accountant, one can really create family offices. So larger families have their own family offices. They appoint full-time people who look after, all compliances, all payments of taxes on immutable properties, transfer of shares from one to another, and then, of course, managing various income, investment, treasury, etc. But I think the people who are having less than 1,000 crore wealth or maybe less than 500 crore wealth are the right people who will be looking of outsourcing family offices as a concept to the chartered accountants or to other people who are able to actually provide this as a professional. Of course, professional role in succession planning is to guide the process carefully, whether you're doing the succession planning yourself or not. But as a chartered accountant, you can guide the team of advocates and the chartered accountants who are doing succession planning as to in which direction and what are the do's and do nots, what care one need to take, how to balance the relationship, and at what stage the succession should happen, whether it can happen immediately on death or whether it can happen thereafter. What can be the planning for? There could be tomorrow, you can say, divorce between the husband and wife, or there could be post-marital issues, there could be extramarital affairs, there could be, there could be various issues actually which are there. We go to the next, please. So now, when we are actually preparing a succession document, one has to question oneself, and I think every single client also have to really say, succession plan, whether it is clearly understood. आपने will बनाई, आपने trust बनाया, क्या ठीक से समझ में आया आपको आपका अपना, या फिर आपने जिस client का बनाया उसे client को अच्छे से समझ में आया. It is very important that it is actually documented in a simple language not in a very, very complex legal language, and it is hardly understood, then I think it will lose the whole purpose. So what is important is the asset should pass to whom you want, the way you want, and the timing also is important when you want. Does the existing plan actually address your various goals? I think we have just discussed personal goals, family goals, financial position and situation. If you need help, then consult. Consult a good chartered accountant. I think he'll be able to help you in estate and succession planning. A professional, a specialized professional is your answer, and your own tax advisor can provide you that support also very, very clearly, very ably. Next, please. Now we'll be coming to the laws, legal part of it. Right now we were talking about the broad. Now I think we'll be becoming more specific. So there could be a interstate and non-testamentary succession. Ananya, will you like to take up this part for 5 minutes? Ananya, if you're around. I think she's not around, it appears. I'll continue in the meanwhile. Akhilesh, you can look for Ananya. Where is she?
So I'll continue.
You will continue from here?
Yes, sir.
For some time. Yeah, please go ahead.
So as you can see, the key inheritance, sir has already explained to us right now the entire reason, why we need to have so as we've already gone through the entire, right now, why we require succession planning, what we need to ensure is that what are the applicable succession laws which are in place. So we have the Hindu succession law, which governs the Hindus. It's very, very clear that Hindu succession law governs everyone except Muslims, Parsis, Christians, and Jews. Then we have, for Muslims, we have Muslim Sharia Personal Application Act. For the Christians and Parsis, they both are governed by the Indian Succession Act, both interstate and testamentary. Now, interstate refers to when a person dies without a will, and testamentary disposition refers to when a person dies with a will, by leaving a document signifying his last wishes. So we're just rectifying that, and in the meantime, I'll just continue. So as I already explained to you, currently the what laws are applicable to which individual. What I'd like to what is pertinent to note over here is that, as we discussed, when an individual dies without a will, Hindu, Jain, Sikh, Buddhist, they're all governed under the Hindu Succession Act. When any Christian, Parsi, or Jew dies without their will, they are governed under the Indian Succession Act. When a Muslim dies without a will, they are governed under the Muslim Sharia Application Act, which is their personal law. If an individual has made a valid will, they are then governed under the Indian Succession Act for Hindu, Jain, Sikh, Buddhist, Parsi, Christians, and Jew, and for Muslims with their own personal law. The next slide.
Screen outage again, huh?
Yes,
I think Ananya, you manage the screen. I think I will continue the presentation. आप स्क्रीन को मैनेज करो बेटा, मेरे को ऐसा लग रहा है कुछ प्रॉब्लम है. दोबारा देखिए, if you can give us a full screen, nothing like it, huh? Otherwise, go to the next slide. Can we move the slide? Now this part Ananya has already explained without a will, of course. You know, one portion which I like to tell you is that how a Hindu is defined in the Hindu Succession Act is for this purpose. Of course, in any case, Jain, Sikhs and Buddhists are all governed by the Hindu Succession Act. But they say anybody who is not a Christian, Parsi or a Jew or a Muslim will be considered as a Hindu for the purpose of succession and will be governed by the Hindu Succession Act. That is what they say. Yeah, now it is perfect. You go to the next slide, please. Yeah. You see, the Hindu Succession Act Section 3 very clearly says that this act is applicable to any person who is a Hindu by religion, in any of the form, whether you could be a Sanatani, you could be Arya Samaji, you could be a Brahmo, you could be Pratana or a Lingayat or a Vaishnav, but will be considered as a Hindu for this purpose. To any person who is a Buddhist, Jain, Sikh by religion, and to any person who is not a Muslim, Christian, this is a residuary clause, Parsi or a Jew by religion, unless is provided by any such person would not have been governed by Hindu law due to any custom or usage as a part of that law. In respect of any other matter, deal with herein if the act has not been passed. If there is any other law which is governing a particular faction or a section, that is of course different. Otherwise, you are governed by the Hindu Succession Act if you are not a Muslim, Christian, Parsi or a Jew. The expression Hindu in any portion of this act shall be construed as if it included a person who, though not a Hindu by religion, is nevertheless a person to whom this act applies. So what it is trying to say is that even if you are not a Hindu, the Hindu Succession Act will apply. In case you are not a Muslim, you are not a Jew. We can go to the next, please. Now, I think there are some more concepts which I want to introduce to you. Agnate, these are the different relationships which will be important for one you need to manage. Agnate is a person said to be an agnate if 1 and 2 are related wholly through males. You are related wholly through males, then you are agnate. You are cognate if you are related to each other by blood or adoption, but not wholly through males. It could be partly through males and partly through females. You are a full blood if two persons are said to be related to each other by full blood when they are descendants from a common ancestor by the same wife. When the common ancestor is also common and the wife is also common, then you are a full blood. If you are a half blood, if you are descendant from a common ancestor but by different wives. You could be uterine blood if two persons said to be related to each other by uterine blood when they are descendants from a common ancestress but by different husbands. So they are called uterine blood. These are of course just concepts. Many times when you are reading judgments and when reading the law, these concepts will come you. This has been defined in the Hindu Succession Act 1956. There are some important definitions we thought we'll bring to you. We go to the next, please. Now you see, we'll be now start touching the Hindu succession law came in 1956 and it continued in a particular manner after 1956 to 2005 when there is a significant change which came. And major change of course has been done in section 6 of the 1956 Act. You know, before the 1956 Act, the position of law was like this, that in every family, you know, once you are born in the family, you become entitled to a property or you become entitled to a right in the property. And as soon as there is a death, the person ceases to have any right in that property. And the daughters were members of the family till the time they are not married. As soon as they are married, they are no more members of the family. That is, I think we are talking of before 1956. And it was primarily rule of survivorship which was saying whosoever survived continue to actually hold the property. So Hindu Succession Act first time provided effective right to women in the property. Section 6 of the 1956 Act in opening line mentioned that the property shall devolve by survivorship. However, wherever, this is however added here, only part change. Then of course thereafter of course it has undergone a very big change. However, wherever there is a female here or a male claiming through a female, the devolution shall take place under the Act. That means as soon as in any family, when we are talking of survivorship in a Hindu succession law, then suppose there is a female here or a male here which is claiming through a female, then of course one has to approach the Hindu Succession Act. So under section 6, the succession was divided into two parts. We are now right now talking about pre-2005 law. Succession in respect of co-partnership property, that's the HUF property, and succession in respect of non-co-partnership properties. So whenever a male Hindu having an interest in Mitakshara co-partnership, if the Mitakshara co-partner died leaving behind a female heir of a class 1 or a male claiming through her, then the interest would devolve by testamentary or interstate succession. Otherwise, it will go by the survivorship. The daughter also did not have any right till 2005 in the joint family property or in the Hindu undivided family property. of course, the daughter, we are aware, were given certain rights in the properties of their father. But when it comes to family properties, till 2005, the daughters had no right of any kind whatsoever in the HUF property or in the joint Hindu family property, and they were neither a co-partner, nor they could ask for a division. But if the daughter is unmarried daughter, in case there is a division, of course she had a share. There was a share. She did not have a right, but she had a share. Similarly, anybody who comes to the family by marriage, maybe the wife of one of the person who, when she joins the family by way of marriage, she automatically becomes a member of the family. Her position continues, but she is in any case not a co-partner, and nor she can ask for the division. But in case there is a division in the family, then she is also entitled to share. What share? How that share is distributed? I think by way of examples and by way of law, we are going to understand as we move further. We go to the next, please. Now, post 2005, a major change comes. According to the revised section 6.1, in a Hindu joint family governed by Mitakshara law, the daughter by birth shall become a co-partner in her own right, in the same manner as a son. She would have the same right in co-partnership property as that of a son. She shall be subject to same liabilities in respect to the said co-partnership property as that of a son. The son and daughter have become equated after 2005, completely equated. As far as the joint Hindu family properties are concerned, we are talking of HUF properties. Any disposition or alienation, including any partition or testamentary disposition of property, which has actually taken place before 20th day of December 2004, that is before the law of 2005 became into effect, shall not get affected. That means this amendment of 2005 will not affect what has already taken place. Suppose there is a partition which has already taken place, you can't really redo it. Or if there is a testamentary disposition by which properties have already been disposed of, in that case that also cannot be affected. But in case there is a testamentary declaration, but it could not be disposed of because by the time 2005 came, then of course the new law will apply. But the earlier action will not get impacted by post 2005 law. We go to the next, please. As per section 6.2, any property to which a female Hindu becomes entitled by virtue of subsection 1 shall be held by her with the incidence of a co-partnership ownership and could be disposed of by her by testamentary disposition. देखिए बहुत बड़ी बात कही हिंदू सक्सेशन लॉ ने 2005 में कि if you are a female Hindu and by way of a succession, in terms of subsection 1, as we have said, the daughters are fully entitled, and if you are a female Hindu, you get any incidence, any share of the co-partnership property or ownership, then you can dispose of that by testamentary disposition. वो फैमिली के हिसाब से नहीं चलेगा. You are entitled to dispose of your own share by testamentary disposition. Similarly, male Hindus in any case were entitled to dispose of their share by way of testamentary disposition, even if it is part of the joint Hindu family property, even before 2005. But I think post 2005, that right is also given to female Hindus. And of course, section 6.3 explain it further, that wherever a Hindu die after the commencement of Hindu Succession Act, his interest, now we are talking of every Hindu, his interest in the property of a joint Hindu family is governed by Mitakshara law, shall devolve by testamentary or interstate succession as the case may be, and not by survivorship. देखिए 2005 कानून में बिल्कुल सर्वाइवरशिप के कानून को खत्म कर दिया. उन्होंने कहा ये खाली सर्वाइवरशिप से नहीं चलेगा. जो आपका अपना शेयर है, इवन इफ योर ओन शेयर इज पार्ट ऑफ द जॉइंट हिंदू फैमिली प्रॉपर्टी और HUF प्रॉपर्टी और द co-partnership प्रॉपर्टी, that will be distributed based on testamentary succession. If you have already decided before your death by way of a will or by other testamentary document, or alternatively, if you have not done so, then by interstate succession as per the interstate law, which we are going to learn hereafter. हम अभी आगे सीखने वाले हैं what is interstate succession, how the proper, when you don't make a will, when you don't decide who will succeed, then the law will decide. That is called interstate succession. And the co-partnership property shall be deemed to have been divided as if the partition had taken place. देखिए ये भी बड़ी इंपॉर्टेंट बात उन्होंने कही, उन्होंने वर्ड यूज किया as if partition had taken place. So whenever there is a death in the family, suppose a male Hindu died, When a male Hindu is dying, I am giving this example by male Hindu, the similar will be true with the daughter also. Suppose a male Hindu die who is a co-partner, and he is leaving behind him his wife, maybe one son, one daughter. So how many people in total? Wife, son, daughter, and he himself. There are 4 people. So what is construed is just immediately before death. There is a legal fiction which is created by the law. It said it shall be deemed that as if it has been divided, as if a partition had taken place. तो आप एज्यूम करेंगे भाई एज इफ एक पार्टीशन हो गया. पार्टीशन हुआ तो जो आदमी की डेथ है उसको 1/4 हिस्सा मिला जो अपने फैक्शन का. सपोज द फादर डाइज, then he may be having 3 brothers, two more brothers, then 1/3 share comes to this faction. Out of that 1/3 share, there are 4 people who are going to share that property. That is the father, the son, the daughter, and the wife. So accordingly, the division will be done. You can say, I will say, as if the partition had taken place, you decide, and then whatever is the share of the father, the person who is dying. We are talking, we can talk it with the same thing with reference to son, with reference to daughter. Right now I am talking with reference to father. So anybody who is dying, who is a co-partner, in case of a co-partner's death, then there is a assumed division in the family, as if just before his death, the property of the family is divided. Accordingly, an assumption is made and the division is planned. And in this particular case, father is entitled to 1/4 of 1/3, 1/3 because balance 2/3 goes to his brothers. So he is entitled to 1/3, and out of 1/3 because he has 3 legal heirs, so it will be divided into 4 portions. So his own portion will be 1/4 of 1/3. So his share is 25%. So अपना 25% share को he can actually do, that will only devolve through testamentary or interstate succession. And in this particular case, even the people, the son, the daughter, and the mother, whatever they are getting on his death, that also they can dispose of by way of testamentary disposition. That is what is section 6.2. We just learned that even a female Hindu becomes entitled by virtue of succession 1, she shall be entitled to actually as if a partition has taken place. They can also go. Alternatively, what we actually really suggest is that even in case of HUF family, it is worth that this father can actually decide that no, we are not going to actually, in case of my death also, we are not going to divide the family, and the family will go to survivors, or it can go to, or his share can go to somebody else. Maybe his entire share can go to his wife, and the son and daughter will get maybe 1/4 share each, and the mother will get maybe 1/4 plus 1/4, that is one half share of the share of this particular fraction. So all that decision can be taken. Or alternatively, the father and the family can take a view and decide that no, we are not going to actually divide the HUF, and let the HUF will continue as it is. And once the decision is taken, there is no question of putting anything into family hodgepodge. But I think if a documentation is done through a testamentary disposition, it can be decided that it will continue with the family. We'll go to the next. I think we'll understand the reference to actual case laws as we go further. Now, post 2005, very, very important things which have happened. We'll go through one by one. The daughter is allotted the same share as allotted to a son. So, जो बेटे को मिला वही बेटी को मिला. The share of predeceased son or predeceased daughter shall be allotted to the surviving child of such predeceased son or such predeceased daughter. The share of a predeceased child of a predeceased son or a predeceased daughter shall be allotted to the child of such predeceased child. So it will go to the next generation and thereafter to the next generation, provided the initial portion, that person has become predeceased. This I think will be run through a chart also. We'll understand it much better through a chart. The interest of a Hindu Mitakshara Upasana shall be deemed to the share of the property that would have been allotted to him as if a partition of property had taken place immediately before his death. That is, I just explained to you. And after the commencement of the Amendment Act, there shall be no obligation on the son. ये देखिए बड़ी important बात उन्होंने कही है. Earlier there was a pious obligation on the children who are inheriting family property to meet the family obligation or the obligation of their parents. But the law very specifically says, after the commencement of the Amendment Act, there will be no pious obligation on the son, grandson, or great grandson for the recovery of any debt due from the father or the grandfather or the great grandfather solely on the ground of pious obligation under the Hindu law. And nothing contained in the amended section shall apply to a partition which has been effected through before 20th day of December 2004. That is what we have already learned. Can we go to the next slide, please? Now, I think we have broadly learned the Hindu succession law as far as the joint Hindu family property is concerned. Now we will be talking about succession on the death of a Hindu male. A Hindu male, we are now talking of how it will go from a Hindu male own a property or own several properties, how they will succeed. So there are different rules. There are class 1 heirs. The class 1 heirs have a equal right among themselves. Everybody share equally at their level. Rule for class 2 here is their rights are in sequence. If in the sequence the first person is available, then nothing goes to the second person. If first person is not there, then it goes to second person. If second is also not there, then it goes to the third in the sequence. And if first, second, third are not there, then it goes to the fourth in the sequence. And then of course we will separately deal with Hindu female, because male female succession is different as far as Hindu Succession Act is concerned. Why? There are of course several reasons. I think we are not going to the why right now, because that philosophical portion we will understand it as we go further. Next please. Yeah. So as per the provision of this act, if a Hindu male dies, the following persons can make a claim. First claim, of course, we have said is class 1 here. The second claim will be for the class 2 heirs. And when the first legal heir, class 1 is also not there, class 2 is also not there, then agnates, as I explained to you, agnates when the people who are related through males, agnates can make a claim. Agnates can be defined as distant blood relatives of male lineage, the father side. Fourth claim, in the absence of first, second, and third, in the absence of class 1, class 2, and agnates, the cognates can do it, that is through the mother side. Now, who are the class 1 here? The class 1 here, son, daughter, widow, mother, son, daughter. You know, they all will get equally. I think I need not really read it. You can quickly read it. I need not read for you. We can go to the next slide because time is running very fast. Whereas class 2, they will, of course, I told you, claim in sequence. If father is alive, suppose class 1 here is not there, and the father is alive, everything will go to the father. If father is not alive, then son's daughter's son, then son's daughter's daughter, and brother's sister, like that, in that order. It will go. So, एक line में जो लिखा है वो सब लोग आपस में they will share among themselves, but this is the sequence. Sequence 1 is father, sequence 2, sequence 3, sequence 4. I think 4 sequences we have shown. If none of the sequences is available, then of course we'll go to class 3. Class 3 is of course agnates, I told you. If agnate are also not there, then it will go to cognates. Next. तो देखिए ये चार्ट बड़े अच्छे से पढ़ लेते हैं, समझ लेते हैं. आई थिंक अगर कोई क्वेश्चन होगा तो हम आपको इसको एड्रेस करेंगे. बट एक चार्ट एकदम सेल्फ एक्सप्लेनेटरी है. विल होल्ड ऑन फॉर a minute or two, maybe about a minute. You can kindly read it carefully. We are talking example of share in property for a male Hindu who die interstate. When it goes to class 1, हमने class 1 explain किया सिर्फ. पढ़ लीजिए इसे अच्छे से. This man, male Hindu, has a son, a daughter, his mother, his widow, a predeceased son, a predeceased daughter. The predeceased son also has one daughter, his widow, and predeceased son and sons. So, even the grandson is predeceased, then it goes to grandson, son, and daughter, and widow of the predeceased grandson. So, this is how it is structured, how the division is done. I think you can really learn it. Now, this will become relevant even in case of HUF. Because in HUF we are aware every faction will have different share. and accordingly, whether the grandfather is dying or the grandson is dying or the father is dying, accordingly, this chart can really help in deciding what will be in his line, how much share is coming. We go to the next, please. Now, in case of a Hindu female, first claim, the son and daughter and the husband can make a claim. That means the female dies, her husband and sons and daughter. This is first claim, nobody else. Neither her mother is entitled nor her father is entitled. Whereas you have seen in case of a male, the mother is entitled, not father, as a first claim. पर ये इनको सबको equal मिलेगा, son, daughter and husband को. Second claim, in the absence of first claimant, the heir of the husband can make a claim. And third claim, in the absence of first and second claimant, the mother and father can make a claim. In the absence of all the three, fourth claim, in the absence of mentioned, the heirs of father can make a claim. And even first, second, third, fourth are not there, then the heirs of father. Go to the next, please. देखिए प्रायोरिटी बताइए ठीक से. I think the same thing has been repeated here, just for better understanding. You can kindly read and try to understand. If there are any questions, we'll be too happy to answer. ये तो पढ़ने समझने की चीज़ हर एक फैमिली में डिफरेंट होगा, तो अकॉर्डिंगली आप डिसाइड कर सकते हैं कौन एंटाइटल्ड है कानून के हिसाब से. Unless there is a will, of course, if there is a will, testamentary succession, then it will happen differently, obviously. It will happen as per the will. And what can be go through testamentary, what cannot go through testamentary, that we are going to just understand hereafter. Please, next, please. Now we'll be understanding. Of course, there are two exceptions to the entire thing what we have said. In case of a female, whatever she gets through succession from her parent side, out of whatever succession law is there, that cannot be inherited by interstate succession. It cannot really go by interstate succession. It cannot go to her husband's side, and whatever she inherit from the husband's side or father-in-law or from that family cannot go to her own family, that is family of her father and mother and the descendants there. So this is also actually provided by the law appropriately. We are not going to the details, because that in specific case what can happen, one can really understand. But moti baat yahi hai, the broad thing is it cannot go cross frontiers, except in case of a you can say testamentary disposition. We go to the next. देखिए हमने चार्ट के तौर पर यहाँ फीमेल इंटरस्टेट को भी दिखाया है, फीमेल हिंदू इंटरस्टेट. आप ध्यान से देख सकते हैं. Kritika ji, अगर आप चाहेंगे तो we'll provide you copies of these presentations, which you can host on the website you have. You can intimate to people. Maybe in the vote of thanks, you can advise how people can access the presentation, because these are very, very important slides, which actually just on the face of it, one is able to really understand what is going to whom actually.
Sure, sir.
So let us go to the next, please. Now, there are very, very important provisions of Hindu Succession Act which we are going to understand, because most of the disputes, as we have seen, as I was explaining initially, happens because of property. Property is the biggest dispute creator, and the dispute can be managed if we manage our succession properly. So, property of a female Hindu to be her absolute property, that is what section 14 is saying, that any property possessed by a female Hindu shall be held by her as full owner thereof and not as a limited owner. तो जो फीमेल हिंदू की प्रॉपर्टी है वो उसकी अपनी प्रॉपर्टी है, वो कोई लिमिटेड ओनर नहीं है. She has all full right actually on that particular property, unless she get a restricted estate through the testamentary or otherwise. Suppose she get a testate only for life, or only for possession, or maybe with limited right. when she gets through either a gift or through will or through other testamentary disposition, she gets something or through a decree or an order or an award, but suppose it is restricted, then in that case, she'll be limited owner even if she is having possession. For example, she might be having possession of one particular flat, maybe first floor, second floor, or whatever, and then it may not. Can Ananya, can you really continue it for a while? Ananya ji, आप continue करेंगे please?
Yes, sir, I'll continue from here. So, as you can see, we've right now discussed what is the position of a Hindu female with respect to the property with her. So, when we're talking about the property of a Hindu female, as per Section 14, is considered to be her absolute property. In this regard, I'd like to bring your attention to these two case laws, which further elaborate on what Section 14 is trying to tell us. So, in the case of Sadhu Singh versus Gurudwara Sahib Narike, it was held that the essential ingredients of applicability of Section 14 are antecedents of the property, possession of the property by female Hindu on the date of commencement of the act, and existence of right in her over it. Mere possession of the property is not enough, and nature of right acquired is important. Subsection 1 of Section 14 applies where a female Hindu is possessed of the property on the date of the act in which she had a pre-existing right, even if the right to be a limited estate or a right to maintain. So what she's trying to essentially state is that if a Hindu female had a limited right also over property on the date of the commencement of this act, after the commencement of the act, she becomes the absolute owner of the property. In the case of Santosh versus Saraswati Bhai, it was, with respect to Section 14.2, it was held that Section 14, subsection 2, is confined to cases where property is acquired by a female Hindu for the first time as a grant without any pre-existing right under a gift, will, instrument, decree, order, or award, the terms of which prescribe a restricted estate in the property. Where the property is acquired by a Hindu female in lieu of a right to maintenance, it is in virtue of a pre-existing right, and such an acquisition would not be within the scope and ambit of Section 14, subsection 2, even if the instrument, decree, order, or award allotting the property to her prescribes a restricted estate in the property. Going towards the next slide. So we've discussed few of the elements of the basic provisions, key provisions of the Hindu Succession Act. Some things which we further wish to discuss and which are also very important, keeping in mind the entire succession planning process. Section 19 of Hindu Succession Act clearly states that if there are two or more heirs who succeed together to a property of an interstate, then they shall take the property as per capita and not as per stripes, and tenants in common and not as joint tenants. What it's essentially trying to state is that if upon the death of an individual, there are two or more heirs, and a house has been devolved upon them, the heirs cannot sell their share without taking permission or without obtaining permission or compensating the other heirs in this case. Second point, with respect to the rights of a child in womb, a child who was, as per Section 20 of the Hindu Succession Act, a child who was in the womb at the time of the death of an intestate and who is subsequently born alive will have the same right to inherit to the intestate as if he or she had been born before the death of the intestate. And the inheritance shall be deemed to vest in such a case with effect from the date of intestate. What this essentially trying to say is that if on the death of a particular individual, on the date of the death of a particular individual, there's a child in the womb, it is assumed on that very day that the child is alive, provided that the child is actually born alive in future. And accordingly, there is a share division, keeping in mind, assuming that the child will be born alive. Third, it's a very common principle of law that no one should benefit from their own wrongdoing, and hence the same is applicable in case of Hindu Succession Act also, which clearly states, and as per Section 25, that any individual who commits murder or abets the commission of murder will be disqualified from inheriting the property of the person murdered or any property in furtherance of the succession to which he or she committed or abetted the commission of the murder. So, if an individual commits murder or abets in the same with the sole intention of succeeding for the toward the property, in that case, that person will be disqualified from inheriting the same. However, in cases where there is an individual has committed suicide, then in such a case, Section 25 will not be applicable. Next, so right now we've discussed the various type of class of heirs which were there in case of Hindu male and Hindu female. Referring to so we looked at a Hindu male where Hindu male had class 1 heirs, class 2, class 3, class 4, and the same was in the case of Hindu female. However, what happens in a situation when a person who's died does not have any heirs in any of those key classes? So in that case, at Section 29, if an individual has died with no heir to qualify to succeed his or her property, then in such a case, the entire property will devolve upon the government. And as we've already been discussing till now, an individual has the right to dispose of any property which is capable of being disposed of by will or by testamentary disposition in terms of Section 30 of Hindu Succession Act. And it is pertinent to know that this will also apply to the right or interest of the deceased in an HUF property also. Now, we've been using a lot of these terms, ancestral property, HUF property, self-acquired property. However, what do these actually mean? We've gone through the bare provisions of the Act, and when we were explaining the definition sections and the important clauses, we did not find anywhere the definition of these terms. And the courts, realizing this loophole, this vagueness, has, by way of plethora of judgments, defined what ancestral property or self-acquired property or HUF property is. So to just give a brief background, ancestral property under Hindu law is known as to be a co-pastoral property. And after the amendment of 2005, even a girl who was born in a joint Hindu family was allowed to take an equal share in the property as that of a son. As Sir has already informed us, prior to this amendment, only male members of the joint Hindu family were known as co-partners, and after the amendment, even female members are permitted.
I'll take it from here. I'll take it from here. So, as Ananya was trying to explain us about the difference between ancestral properties and self-acquired property, in case of self-acquired property, it is any property which is purchased either by your own money or on division of any ancestral or co-pastoral property if you have got the share through a testamentary document. Suppose even if it is ancestral property or if it is a co-pastoral property, but you got that share through a testamentary document like a will, in that case, it will be as good as a self-acquired property. So that means either you have earned that money on your own by your own effort, that is of course self-acquired. But suppose it is ancestral, maybe suppose it is your father's property, it comes to you through a testamentary document, in that case it is not ancestral property, then it will be considered as self-acquired property. That is how the law is. And even if suppose it is a HUF property, and it comes after the death of Mr. A to Mr. B, through a testamentary document, the share of Mr. A comes to Mr. B through a testamentary document, in that case it becomes a self-acquired property. I think that is what is the major distinction which one needs to actually really understand. A very, very ticklish issue, but I think as we go further, we will further refine it. Go to next, please. You see, in this particular case, property inherited from paternal ancestral is ancestral property. Now, that what they are saying is, what is ancestral property? Ancestral property is any property. Now we are not talking of the HUF property or the joint Hindu family property. We are talking of ancestral property. Let us distinguish between joint Hindu family property is for the whole family. Ancestral property, when we are talking about, any property which you inherit from your paternal ancestor is ancestral property. So if a person inherits such property, if you have no son, grandson or grandson's sons in existence at the time of inheritance, then of course it comes as individual property. But in case you have any one of the son, grandson or great-grandson in existence, then whatever comes from your parents, that is the paternal side, that is from a male Hindu. Right? That means whatever comes from your father or from your grandfather or from your great-grandfather, whatever is coming to you through succession. We are not talking of testate succession or testamentary succession. We are talking of intestate succession. So where whatever it comes in the normal course of interstate without any will, etc., succession from your father or from your grandfather or from your great-grandfather will be the ancestral property, in which automatically your son, your grandson, your grandson's son will be actually entitled in that property, and you will not be the absolute owner of the property. And he can also, stop you from, transferring or alienating that property. Once we see this 2018 judgment, which is actually a post 2005 judgment, it refined it further. Any property inherited up to 4 generation of male lineage, that means whatever you have inherited from any of the last 4 generation, that is from your father, father's father, father's father's father, that is father, grandfather, etc. In terms of ancestral property, we are talking of 4 generation. Property inherited from mother, grandmother, uncle and even brother is not ancestral property. तो आपको जो अपनी मदर से मिला, ग्रैंड मदर से मिला, चाचा से मिला, भाई से मिला, that is actually not an ancestral property. That is your self-acquired property for all practical purposes. But if you have got anything from your father or you're from grandfather or great-grandfather, or suppose something came from your father or grandfather, and that from that money you started a business and that keeps on growing, then even on that business, also there could be you can say a right of your successors. Because then entire property which is developed based on the ancestral property will also be considered as ancestral property for all practical purposes. So the Supreme Court judgment of T.B. Raju, Mangamal versus T.B. Raju 2018 judgment has a very, very crucial bearing. This is appeal of 2009 and which has come to 2018 for hearing and judgment. We go to the next, please. So I think what is a self-acquired property? Normally as we told you, it will remain a self-acquired property. Suppose you have no son, no grandson, no great-grandson, and it is coming from your father, then it is your property. But once the son is born, it becomes a co-pastoral property and he would acquire an interest therein. So we are not talking of a joint Hindu family property because this is a 2006 judgment and it relates to old, but it is only saying that today you have no son, you got a property from your father, it is your absolute property, you can sell to anybody, you can dispose it of in any manner, you can alienate it in any manner, you can gift it to somebody, anything you can do. But as soon as your son is born, then he can stop you from transferring that property. So you see, whenever we are in the process of acquiring properties, buying properties, doing transactions in properties, these judgments will have a very, very important bearing. And if you are dealing with somebody who has inherited a property from his father or grandfather or great-grandfather, it is very, very important that his children, that is his son, his grandson and his great-grandson, if they are alive, their consent is taken for the disposal. Otherwise, they can actually, stop, they can really put an injunction or they can really trouble you in any manner. We go to the next, please. Now, Govind Bhai, Chota Bhai, I think this is Supreme Court judgment of 2019. It is further elaborating what is self-acquired property. Self-acquired property, a father has the absolute right of disposition over his self-acquired property, to which no exception can be taken by his male descendant. आपकी अपनी property, आपके male descendant उसमें कुछ नहीं कह सकते. It was held that it was not possible to hold that such property bequeathed or gifted to a son must necessarily rank as an ancestral property. तो माननीय सुप्रीम कोर्ट ने कहा कि if Mr. A actually created this property, the self-acquired property of Mr. A, but he has bequeathed that property by testamentary disposition to his son, or he has gifted it, or he has given by way of will, then it will not rank as ancestral property. Property gifted by father to his son could not become ancestral property in the hands of the donee simply by reason of the fact that the donee got it from his father or an ancestor. So we go to the next, please. I think we might have to stop in another 5-7 minutes because it is already 17:32. I will be only covering if a person after 1956 inherits a property from his ancestral paternal ancestors, the said property is not a HUF property. HUF existed and continued before and after 1956. So what we are talking is, this is an old judgment. If you, how a property become a HUF property, there are only two alternatives which they have said. Either there was an existing HUF and the same HUF continues, or alternatively, an individual property is put into a common hodgepodge. Just because it is an ancestral property, it does not become a HUF property. Because HUF rules of the game are different, and ancestral property inheritance rules are different, as we have just now seen by the Hindu Succession Act. So accordingly, one needs to decide whether it is HUF property. If it is put into common hodgepodge, it becomes a HUF property. Next, please. Okay, HUF can also exist if paternal ancestral properties are inherited prior to 1956 and has continued after 1956. I think this is again confirmed by the Delhi High Court. In the same manner, you can go through these judgments which will be hosted, and I think it will become more and more clear to you. We can go to the next, please. अरे एक दो स्लाइड्स और कर लेते हैं. वो पार्सनरी प्रॉपर्टी को मेरे ख्याल से इसमें सिर्फ वन हैज टू बियर इन माइंड. आई थिंक आई एम नॉट एबल टू सी दिस portion. Not very clear to me. Only male members of the family used to acquire by birth an interest in the co-parsonary property. A co-parsoner has no definite share in the co-parsonary property, but he has an undivided interest in it, and one has to bear in mind that it enlarges by death, every death in the family, and it becomes, it reduces by every birth in the family. अगर आपकी family में, if you have one son, then and maybe your wife, then you have only three shareholders, and one third each you own in a joint Hindu family. Another son is born, then you become 4 claimant, 1/4 each. Another daughter is born, then I think 1/5 each. That is how it happens actually. We go to the next, please. I think it's a long way. We go to the next. Joint in the family property. There are some more judgments which we are giving you. Anana, do we go have one or two more important slides to be shown?
Yes, I'll just shift us to that.
Shift it to the important slides, because time is short, no? You just go to this power attorney thing. Just go back 1 minute. I'll just deal with this. The Honorable Supreme Court has held in a 2009 judgment, Suraj Lamp, with a very important judgment, that the transaction, the nature of GPA sales, whether it is special power attorney or general power attorney, do not convey any title. You know, people have been transferring agreement to sell kar liya, GPA kar liya, or will kar liya. You know, it does not convey any title and do not amount to transfer. The Honorable Supreme Court has said that the transactions in immovable properties are illegal and cannot be enforced in case they are supported only by way of agreement to sell, or a general power attorney, or a will, or a combination of them. Because it is very, very important to get themselves registered. You know, after this has happened, a large number of state governments have allowed registration of properties on the basis of power attorney. And power attorney you can give to your near relative only. That is also there. Now there are detailed rules in every state. Delhi state has different rules. Haryana is different, and accordingly one has to manage. We go to the next. I think we will have a small break now for about 5 minutes, 5-7 minutes. We'll have a break, and then we'll take up. And then we'll do a break. I think we'll be joining at 17:45. 8 minutes or 17:50. 17:50 is better. 30 minutes break. I think everybody will be looking for a break. So 17:50 we'll again join. Thanks to everybody. Ritika ji, can we start? It is going to be 17:50.
Yes, we can.
Sir Chawla sahab, shuru karen?
Yes, we can.
We can start, no? Agar Jyoti sahab, you are also there, yeah. So I think we will be now going to the second part of our presentation. The scope of presentation will be talking about the will, probate, the trust, the meaning of the trust, advantages and planning potential, domestic and international trust, and of course the tax planning and other part which is possible through domestic and international trust. So this is the broad coverage which we are going to do. Of course, we'll go through in details first the will portion, the will, probate and trust. So what is the will? Every individual who is a major, देखिए एक चीज बड़ी important है, you have to be a major before you actually execute a will. Minors are not allowed. Of sound mind. So one needs to actually establish when you actually written your will, you were of sound mind, and it was done with free consent. He is capable of making a will, because most of the dispute happened on the basis of whether it was done without free consent, whether he was of sound mind at that time, he was already ill, he was significantly ill. At that time the will was done, so he was not of sound mind. And of course one has to be major. Now the key consideration while we actually look at the will is you can bequeath specific assets. For example, painting, art, jewelry, securities. You can immutable properties, movable properties, bank balances. It can go specific case by case. X property to Mr. A, Y property to Mr. B, like that. You can always decide specific assets. Then beneficiary waterfall. There could be primary beneficiaries, there could be secondary beneficiaries, there could be ultimately beneficiaries, and sometimes primary beneficiary may be having a full-fledged right during his lifetime. Sometimes he only have a life interest, or sometimes he only possession interest. There are different kind of the permutation combination one can do while you're drafting your will, while you're determining your succession plan. Of course, one has to choose very carefully the executors and the witnesses. Who is an executor? What is his role? I think that we are going to really understand very carefully. The role of witness is also very important, because whenever the question will come as to whether the person who was executing the will, at what time he executed the will, which part of the whether the time and the date which is written is the right time and date, where that time he was actually in India, whether he was available, whether there was a free consent with which he did it, and whether he was of sound mind. So the role of witnesses becomes very, very important. So choose your witnesses very carefully. And of course, executors also in any case one need to actually choose carefully. Witness could be one of the beneficiaries also, need not be beneficiaries. Similarly, executors can be one of the beneficiaries, may not be one of the beneficiaries. Most of the people we have seen keep one of the person who is of their great confidence as the executor, who is part of the beneficiary waterfall. The process of applying for probate and letter of administration also we are going to really deal with. What are the difficulties one can have in that process, and whether the will has to be registered, etc. We are going to deal everything. We go to the next, please. What is a will? A will which is the last will. The word last will is very important, because once you have made a will in 2011, 2012 you revised it, 2013 you actually scrapped the earlier will and made a new will, and you die in 2022. So between 2013 and 2022, whether you made a will or not, or whether the 2013 will was your last will or not, becomes a matter of debate sometime. So a last will is of course a testamentary document. It is a legal document designed to tell the probate court what to do with your assets after your death, at your death. A will must be complying with the law. It should be in accordance with the law. It has to be in writing. An oral will is very, very difficult to administer. It will be very difficult to actually, provide necessary evidence in case of oral will. So I think it is necessary as per law to have the will in writing. Whether to register, how to execute is the question which we are going to actually determine as we go further. We go to the next. So a lot of practical considerations we have to actually, based on our experience, we are sharing with you. The will must clearly set out the intention of the testator to bequeath his assets unambiguously. Every single word is important. One is there has to be intention of the testator which should come out that he is writing a will. It is not just like that he is writing a letter or something which is not intending to bequeath his asset, his estate after his death. The whole process has to come out very, very clearly, unambiguously. Just like that, if you really write something, it may not be treated as a will alone. It may not be treated as a will, but it cannot be your will. There is a big difference between letter of wishes and the will. The will has to clearly come out the intention of the testator to bequeath his estate in an unambiguous manner. Will can be revoked at any time during the lifetime of the testator. At any time, you write another will, the previous will becomes infructuous, or you can actually cancel that earlier will and make a new will. You can amend a will by way of a codicil. Only a supplementary will you actually execute for some additional properties or for some other beneficiaries, or amending the earlier will, amending the beneficiaries, so you can write a codicil, or you can completely rewrite your will. Codicil is an amendment will, is called codicil. A will is not required to be stamped. There is no stamp duty payable on a will. A will need not be registered. You know, when we are saying need not be registered, but we actually suggest that a will, if possible, should be registered. Why it should be registered? Because it becomes more legal evidentiary value about the initial part what I was saying, that whether the same person whose signatures are there, he is the same person who has signed, his identity is proper, and he was a sound mind, and he has done it with free will. All these aspects becomes much important. But once a will is registered and you want to actually modify it, that modification or cancellation also should be registered. Or if you want to make another will in place of the earlier will, then the later will also should be registered. Because suppose you made a registered will 2013 and then you write a will which is not registered in 2022 and which is only written in a piece of paper in the presence of some witnesses, then I think for a court to really determine which will is actually you can say has to be acted upon, will become difficult and will become a matter which will become subject matter of debate and litigation and dispute. A will need not be printed on legal paper. It may be printed on a plain paper as well. Legal paper is not necessary. International will probate outside the country can be enforced in India, subject to an application made to a relevant court seeking letter of administration for the Indian estate mentioned in the will. Suppose you have a client who is based in US, he has a lot of assets in India, then he can always create a will wherever he is. He can sign and execute a will there. That will can also be enforced in India, subject to application made in relevant court in India, wherever the jurisdiction is in India, to obtain a letter of administration for the Indian estate mentioned in the will. But I think what we will suggest is that actually practically what we'll suggest is that the will for Indian estate and properties can be a separate will, and the will for different countries, you have assets in US, you have assets in Nigeria, you have assets in Singapore or in Dubai. So for separate countries, it is better to have a separate will with cross-referencing to each other, that these are the will which is specifically for, and you can have one will as a master will which actually talks about and execute. Now, how do you actually get executed? Suppose it is not becoming possible for you to go and register your will everywhere. At least, you know, what you can do is, suppose you are in US and you have a lot of Indian assets, you can go to commercial consulate in the embassy, in the Indian embassy, and execute your will for the Indian assets in the presence of the authorities there. You can get it notarized also locally there. But it is very, very important that it is also attested by the Indian embassy. Then it will become it will become much more easier to get it recognized by the relevant court in India. But suppose you have just written a plain piece of paper, you are sitting in US or in UK, that my assets in India will go to so and so. It is not registered anywhere. It is not even evidenced by the local embassy. Not even notarization is there from the relevant country. It will become very, very difficult, and there may be many disputes which may arise. And to satisfy the court, it will take maybe much longer time. We go to the next, please. Now, these are the advantages of registration, evidence of execution by the testator. With respect to the mental state and health of the testator, evidence of execution with free will without any coercion or influence. Safe custody of will and certified copies can be obtained at any time. ये बड़ा important aspect है safe custody. You have executed the will, but it is not traceable. Where to keep that will is also become a big question of an unregistered will. And even if it is registered, somebody need to know, at least your executor need to know, and at least one or two more persons, maybe your tax advisor should know that there is a will which is lying with in the safe custody. And litigation relating to existence, genuinity, forgery, they get reduced very significantly. I'll say only they get reduced. It doesn't go completely, because there can be forgery, there can be ingenuine will even when it is registered. So one has to do it very, very carefully. Disadvantages: difficult to amend or withdraw or revoke to be registered again. A last will which is not registered may be questioned by a pre-existing registered will as genuine. Privacy and confidentiality may be compromised because it is duly registered. There are people, unwanted people may sometime obtain copies if they know that there is a will which is there, and you may not like to actually really do it. Sometimes when you're executing a will without getting it registered, it may be worthwhile to record the proceedings, a video recording as well as audio recording, and it may be also worthwhile to obtain a certificate from a doctor, preferably from a government hospital, that the person concerned, whoever is making a will, is of a sound mind. So specifically for people who have grown in age beyond, has become senior citizens, it becomes very, very important to take a certificate from an appropriate doctor, preferably of a government hospital, that yes, this person is of a sound mind and he can execute any agreement or execute a will or whatever is required to be done. We go to the next, please. Now, a will can address actually all kind of issues in various kind of property rights. You see, freehold property rights are transferable differently, leasehold are transferred differently. You may have a long lease of a property, you may have a 99 years lease, and later on you might have an option of getting it converted into a freehold, or you may have only a 10-year leasehold property, or you may have a 30 years leasehold property. How this will get transferred, I think all that can be addressed through a will. There could be a joint ownership, there could be a property which is owned as either or survivor, there could be only a tenancy right. Sometimes tenancy rights are also very, very important tenancy rights. And as per, for example, as per Delhi, I am aware, as per Delhi rent control law, in case you are having a tenancy, the tenancy can be actually be transferred to your successor through a will, or maybe through interstate succession, of course, both. But when it is done through a will, then there is no dispute about who will actually occupy that property after the occupier has died. There could be licenses, there could be rights, there could be partnership rights, there could be rights as a trustee, there could be management rights, there could be goodwill, intellectual property rights, there could be copyrights, there could be anything. There could be a software which you have written, or there is a patent in your name, there could be anything. It's a long list, but I think your will is an answer to all varieties of your different things which you can really handle. Next, please. Restriction on transfer in case of a will. Whether you can actually restrict the person to whom actually you are transferred by a will. There are few sections of the Indian Succession Act which becomes relevant. Bequeath to a person by a particular description who is not in existence at the testator death is actually not allowed, not permitted. Then bequest to a person not in existence at testator death subject to prior bequest. Subject to existence of testator death, subject to prior bequest. This is also not permitted. So suppose you want to create perpetuity through your will. Perpetuity is not allowed. Neither in India, most of the international jurisdiction, it is not allowed. Even suppose you want to create a trust, which is a perpetual trust through will, that is not permitted, because perpetuity is not allowed. In most of the jurisdiction, for example, Singapore actually restrict the maximum trust life to be 100 years. Bequest to a class, some of whom may come under Rule 113. Suppose you want to do it as a class who are subject to prior bequest, then also it is not permitted. And of course 114 also. A combination of them can also not be done. Bequest to take effect on failure of prior bequest. अगर आपने एक किया, उसकी failure अगर हुई तो दूसरा होगा, that is also not permitted by the law. Let us go to the next. एक बड़ी इंपॉर्टेंट बात है कि आप कोई भी विल करेंगे अपनी शादी के पहले, so it will get automatically revoked on marriage. So whether it is first marriage or second marriage or third marriage, after every marriage, the will of a male or a female both will get automatically revoked as per the by efflux of law section 69 of the Indian Succession Act. No unprivileged will or codicil nor any part of theirs shall be revoked. Suppose you want to do a revoke, you can do it by either by a marriage, automatically it gets revoked. You can make another will, then also it get revoked. You make a codicil for amendment, then the earlier one of course get modified. Suppose you create a written document which shows your declaration or intention to revoke the will, then also suppose आप जला दें, फाड़ दें या otherwise destroy कर दें by the testator or at my instance or by testator instance by somebody else in the presence of the testator, so with the intention of revoking, then also it get revoked. That is what section 70 is permitting. Next please. अब देखिए एग्जीक्यूटर का क्या रोल है. हमने बताया कि फिड्यूशियरी रिलेशनशिप एग्जीक्यूटर की पड़ी. He helped the person who has written the will to execute the will to get it implemented. Execute means implemented after the death of the person whose assets it is. The first role is to obtain a probate or a letter of administration if it is required, to look after and manage the property under the will till the time it is actually transferred to the respective beneficiaries, to deal or dispose of the property in a manner desired or required by the will. Many times your will may say, this is my house where I am living, it should be sold on after my death and should be divided 1/3 to so and so, 10% to so and so, 5% to so and so. Like that, there could be a division. So I think then executor might have to actually dispose of the property, realize it, and then of course distribute it. To take inventory and account of the estate also is his responsibility. To incur various expenses on medical and other services taken by testator in 3 months immediately before his death. वो also उसकी जिम्मेवारी है, एग्जीक्यूटर की सबसे पहली जिम्मेवारी है पिछले 3 महीने का जो मेडिकल का खर्चा है और है या उसके फ्यूनरल का खर्चा है वो उसमें से विल के पैसों से उठाए. टू डिस्चार्ज डेट ड्यू एट द टाइम ऑफ डेथ ऑफ द टेस्टेटर. कोई भी अगर टेस्टेटर की डेट है, मान लिया मेरी एसेट है, प्रॉपर्टी है, उसके अगेंस्ट बैंक का लोन है, तो उसको भी चुकाने का काम एग्जीक्यूटर का है. टू पे लीगेसी ओनली आफ्टर इंडेमनिफिकेशन ऑफ कंटिजेंट लायबिलिटी. टू डू लीगेसी मीन्स सपोज यू आर पेइंग some 1 lakh rupees per month as per will to somebody for next 36 months or maybe for all of the life. There could be n number of things which could be given to the executor. So I think after indemnification of contingent liability, you can of course also start paying that legacy. Legacy also might be involved. Transfer legacy may also involve the transfer of the entire property itself is also paying the legacy. Next please. Now, step for enforcement or receiving inheritance. Because there are 3 alternative ways through which you can actually enforce the will or other testamentary disposition. One is of course probate. Probate of course is mandatory in certain states like Maharashtra. Probate, they are granted to executor identified in the will. It is given in his favor. Based on that probate, the executor will get all powers to actually dispose of the property in terms of the will and in terms of the order of the Honorable Court who has issued that probate. Letter of administration is granted to a relative of a deceased if the deceased died intestate. There is a death intestate, then a relative of deceased can approach the court and get a letter of administration to dispose of the property as per intestate succession. Legal heirship certificate is issued by district magistrate, and accordingly, based on that, the decision can be taken that who will succeed it. But I think if there is a will, then I think the number 2 and number 3 might not become necessary. So that's why we suggest that every single taxpayer or even non-taxpayers may be persuaded, may be advised to execute a will so that it becomes simple. Get it registered, it will become more simple. And then steps you have to apply to a competent court depending on High Court or Supreme Court or High Court or District Court depending on the amount involved. Of course, the court fee is required to be paid from 2% to 8% depending on state to state on the value of on the pecuniary value as may be determined by the High Court or the District Court. For that, of course, a valuation report might be required to be submitted to the Honorable Court. Notice to next of the kin. I think all the notices have to be given to all the people who are inheriting the property, who are supposed to inherit. That next of kin means your daughter, your son, your wife, and all close relatives are actually notified that there is an application which has been filed for probate. You need to publish a newspaper regarding request for grant of probate, and list of assets to be submitted for valuation. If uncontested probate letter of administration is issued, in case of a probate is an authenticated copy of the will is annexed, it is granted faster. Otherwise, if it is contested, it will go to a civil suit. Process normally take about 1 to 1.5 years of a uncontested probate. In case of contested, then it can take any number of years. That, of course, depending on what is the kind of dispute which is involved. So then I think court will take a lot of time. There could be decision of the court. There could be then one needs to go to the division bench. Then maybe from division bench to Supreme Court. Then back to High Court for further examination of certain aspect like that. It will go on. And if you start from district court, then of course there are 3-4 levels. We go to the next, please. Now, upon grant of probate oblique letter of administration, the executor becomes the deceased legal representative and property is vested in him. In case the will require transfer or disposition of property, then you can do. In case of interstate succession, the administrator appointed by court will play the same role. Nominee, once there is a nominee which is written, the properties can be transferred to the nominee's name. More importantly, we are talking of the movable properties. Can be transferred if it already nomination has been filed with the bank or with the depository participant, or it is duly registered nomination with the bank and other company, corporate, wherever you are actually holding maybe debentures and other securities. If nomination is already registered, so nominee is actually not the owner, but is entitled to dispose of the property in terms of will or succession law. So this is also a decision which has been taken by the court several times, that suppose a nomination is done in the name of one son and there is no will, whether other people are actually entitled to a share. Yes, they are entitled to share as per the Indian succession law. Of course, if there is a will accordingly. If there is no will, then as per Hindu Succession Act, of course it will go. And of course there are regular debate on such matters because of most of the people are dying interstate, and that's how there is a lot of dispute in the courts between the legal heirs, between the mother of the deceased and the wife of the deceased, between the brothers and sisters, between the sons and daughters. There are a lot of disputed issues. So avoid all dispute, create a proper will. I think that is our suggestion. Go to the next, please. Now, probate. Probate are various kinds. There could be a living probate. There could be a death probate. A death probate means a probate which is obtained after the death. Living probate is when the person is living. You actually decide and get it actually. Living probate or guardianship actually suppose will apply only in case when person is living but he has become incapacitated, or he cannot take any financial or healthcare decisions. Court can appoint in absence of a clear documented plan. Court can appoint a guardian. If already in your will or other document it is there, then accordingly a living probate can be decided. In case of a disability plan option also, there could be a living revocable trust, or there could be a healthcare power attorney, or there could be living will. There are several examples which are there. Accordingly one can manage, because as I explained to you in the beginning that life is very uncertain, health is also very uncertain, and capacity to take decisions can go away from anybody. We have seen people losing their memory. There are people who stop recognizing their own people. Sometimes people are not able to even recognize themselves, and they don't know what property they own, which property is where. All that decision making, all that knowledge goes away sometimes by a flicker of a button, or maybe you can say because of the efflux of the nature's cause. Go to the next, please. Now, what is the probate after death? Is a legal proceeding. I think that is this we have already explained to you. I need not really repeat this. We can go to the next slide, please. Now, death probate issues are that there is going to be delay, that there can be going to be cost. I have told you 2% to 8% the court fee, then the lawyers, then the presentation, then so many things are there. Of course, publicity will also have to be done. In case of a death probate, you need to advertise. There could be contesting, there could be control issue, who control the asset in the meanwhile when the disposal is going on. Multiple probate in case assets are in different jurisdiction. You have properties in India, you have properties in Dubai, you have properties in Australia, you have properties in Japan. So, of course, every location will require a different process. We go to the next, please. So, everybody gets worried. Why to get into this probate? यार बड़ा झमेला है, क्यों करना चाहिए? कोई रास्ता निकालो भाई. तो बहुत सारे रास्ते हैं, कितने अच्छे हैं, कितने नहीं अच्छे हैं, इनको हम समझते हैं. देखिए, the first option is giving away assets. That means during your lifetime. I remember a very close client of ours. He came. He said, "I want to really do my succession planning." I said, "What do you want to do?" He said, Jan Saab, I know that probate is going to really create a big problem for my children. So at least 2/3 of my assets I want to give away right now to my son, to my daughter-in-law, and to my grandchildren. Whatever I want to transfer, I'll transfer now. Then, what are the difficulties arising out of giving away assets? I think we are going to talk in the next slides. You can use joint and contractual form of property ownership. You can have either or, survivor, etc. That also we are going to discuss. Nomination for final asset is a good alternative, so that at least all financial assets can go to your nominee, and nominee can actually execute them in accordance with your wishes, as you have either given letter of wishes or you have executed a will. Using a revocable living trust, you can also create a living trust. I think that also will explain to you how a living trust can help you. This is a very significant part, and this is becoming more and more popular actually for several reasons. We go to the next. In the alternative one, when you give away assets, you lose control. The control itself is lost on the asset because you already transferred it to so and so. And then he is fully entitled. Property may not be used as you wish. He may use the property in his own manner. आपने property को बहुत प्यार से बनाया, आपकी नजरों के सामने ही. It can be disposed of. It can be rented out. It can be misused, and you will not be able to do anything once you have given it away. And once you have transferred your assets, whether you will be taken care. I know last month a chartered accountant has been telephoning me time and again. Jan Sahab, my son is in US. He's actually made my life very, very difficult. He keeps on telling me, you have this liberalized remittance scheme. Why don't you transfer $250,000 to me every year? And maybe a similar amount you can transfer from the mother's side, sell your assets and send to me. I need the money. I asked him whether he's working there. He said, yes, he's working there. He has good assets, but he wants all my assets. So I think this depends on how much asset you have, how much you will need for your old days, and you don't know how long you are going to live. You might be 60 years, you may go while you are 65, and you may go up to 90, you may go up to even 100. I think we saw the other day in the Honorable Rashtrapati ji, he was trying to, give an award to somebody who is 126 years old. So you have to actually determine whether because earning capacity is going to go away, and if you give away, what will happen to you? Whether children, and of course another risk, the children's creditors and other claimant from children, including their spouse, can really make their life miserable and can take away the assets given by you. What happens if the child predeceases you? आपने बेटे के नाम में ट्रांसफर कर दी, बेटी के नाम में ट्रांसफर कर दी, पता लगा चाइल्ड ही प्रीडिसीज हो गया, फिर क्या करेंगे? फिर प्रॉब्लम आ गई कि उसकी प्रोवेट चाहिए, वो कहाँ जाएगा? और then there could be a claim by son-in-law or daughter-in-law on your transferred property. If there is a divorce or post-marriage issue could be there. There could be extramarital issues. There could be anything. तो बहुत ध्यान से करने वाली चीज है. Give away asset, saying is simple, but I think personally, based on experience, I feel partly one can really think in that direction, but at least not fully. Maybe some portion you can give if you really want to reduce your harassment. You can always do this. Thank you. We go to the next. Now, there are several ways, people create ownership. Sometimes they create joint ownership with the right of survivorship. There could be equal share. There could be undivided share. There could be either or survivor. Most commonly, married couples, they take joint properties without even realizing what does it really mean. आपने husband wife के नाम में property खरीद लिया, बहुत खुश हो यार, चलो मैंने wife को take care कर लिया. But आपने अगर बीच में बेचनी पड़ी है, you need her consent to sell or even create a charge. You need some money. She said, no, you cannot create a charge. I don't give you consent. On death of one spouse, the property will vest with her survivors. or maybe your husband survivors. आपने joint property ली अपने husband के साथ मिलके, husband की death हो गई, तो उसके बाद वो that property goes to, a part of the property goes to his mother, and sometime to he has already given a testamentary documentation. It can go to anybody, it can go even to a third party. So you have to be careful. So on your death, you cannot control how the property will be used. आपके बाद प्रॉपर्टी कैसे यूज होगी, ऑफ कोर्स आप बता ही नहीं सकते हैं. कल को जॉइंट प्रॉपर्टी आपने ली है, डाइवोर्स होगा, रीमैरिज भी कर सकती हैं आपकी वाइफ या आपका हस्बैंड. सो आई थिंक ऑल दोज इश्यूज यू कैन नॉट मैनेज by this ownership structuring. Joint ownership with children or others will have more complication, similar to giving away of assets. There could be, these kind of issues. And we can go to the next, please. अरेना आपने बीच में कहीं ऐड करना तो you can always interject, okay? And अखिलेश आप भी चाहें तो interject कर सकते हैं, please, anywhere. Wherever you want to add anything, please go ahead.
Yes, sir. Yes, sir. Of course, we will.
ठीक है ना, आप इंटरजेक्ट कर लेना मेरे को without any difficulty. So the third alternative is nomination. It is possible for LIC, proceeds, fixed deposits, mutual funds, shares, securities, and other similar movable assets. You cannot give instructions to nominee as to how to use proceeds, unless there is a letter of wishes which is executed between you and the nominee. In normal course, you just create a nomination. What he will do, you don't know. And most of the places that nominee will not even let anybody know that he got that property from you. There might be 5 years, but to nominee को भी पता लगेगा, किसी को पता नहीं लगे, ऐसा भी हो सकता है. So you have to do it very carefully, whether you really intend to give entire property to that nominee, because there is a tendency of nominees not to give it to anybody else. And except I think in Maharashtra, in the Bombay High Court, there is a judgment which says that in case of shareholdings, the nominee has the final title. Although in case of rest of the properties and in the rest of the country, there is no such court-made law. Also, all the courts have taken a view that nomination do not convey title, and the nominee is only entitled to deal or dispose of the property as per the will or as per the interstate succession. Nomination is subject to your will and interstate succession. Amending nomination for each property is onerous task in case of need. In case of demat asset, change of nomination is simple. For all the companies, it will happen in one go. Just you go to a DP participant and you can change it. But how do you do it? In case of private limited companies, becomes very difficult, because private limited companies normally do not have a proper procedure of nomination, and even if they have, whether how to create necessary evidence, whether the nomination should be filed with MCA 21 also is a very important thing which you can examine. I feel personally that if you want to actually nominate your shares which you are holding in a private limited company or a public limited company which is not listed or which is not dematted, in that case it will make sense that the nomination is executed, and if GLN form is filed by the company along with the board resolution which is accepting that nomination, that it is taken on record, I think then it will become a public document. But it will become public document that nomination, and then of course it cannot be withdrawn. Alternatively, what you can do is you can also have a board resolution, and that nomination can be really kept in safe custody of a banker, and that aspect can be filed with the GLN form. So I think there are several options which one can decide. We can go to the next, please. Now, living trust is a very interesting example of how do you really do it. While you are already alive, you have legal title of property, they are held by the trustees. Once you transfer it to the trust, you settle the trust. I think we are going to also examine in detail how a trust is administered, trust ke kya ifs and buts hai, as we go further. But I think first let us talk of living trust. So legal title of the property is transferred to the trustee. He is not beneficial owner. He is only legal title he has. Beneficial enjoyment or use by beneficiary or beneficiaries as may be specified with waterfall mechanism. What is waterfall mechanism? There could be a primary beneficiary, could be possibly, for example, your wife. The secondary beneficiaries after your death may be your children, and ultimate beneficiary could be your grandchildren after your son and daughter and your wife also pass away. So there could be a 3-level, or sometimes people keep primary beneficiary as themselves. Most of the cases we see that the settler keep himself as the primary beneficiary. Sometimes he add his wife as well as a primary beneficiary along with him. And then maybe secondary beneficiaries are children, and ultimate beneficiaries are grandchildren. So a trust created during lifetime of the owner, the settler, is called a living trust. It can contain detailed instructions on uses of properties and how to use different benefits. Living trust could be revocable and it can be irrevocable. Even revocable trust also give a very, very interesting idea. Suppose you have a property and you want to actually do a living trust and transfer it to is a revocable trust which you have created. So that entire income from that property will continue to get assessed in your name because it is revocable trust. So there is going to be a clubbing in your hand. So in case of a revocable trust, it will not going it with everything as usual except this. And if you are the settler come trustee, in that case even the property can continue in your name. A very large number of people do that because they are able to in this process set up a waterfall mechanism. Who is the secondary beneficiary? Who is the next beneficiary? Because this trust deed, once it is registered, then it becomes an implementable document accordingly. And of course, in case of irrevocable trust, there's no you can say there's no clubbing of income. And I think how it will be taxed, of course, we will be discussing broadly. I've explained in my initial part, in the first part, the taxation aspect. But once trust is irrevocable, then once the assets are transferred to a trust, they cannot be cancelled except with the consent of all the beneficiaries or the manner in which the trust deed prescribed. We go to the next, please. तो देखिए, method of succession planning हमने बताया अभी आपको through a family trust, or we sometimes call it private trust. It is not a public charitable trust which you are talking about. We are talking a family trust or a private trust. It could be a living trust. It could be a testamentary trust. Living trust is created during the lifetime of a person. Testamentary trust is created after the death through a pre-existing will. For administration and management and administration of properties, even during the lifetime and thereafter, is the living trust. And testamentary trust is it will manage and distribute the properties as authorized in terms of the trust deed and as determined by the trustees in accordance with the trust deed. Of course, through a will, you can distribute the properties through will to the specific persons. That is another alternative. देखिए, दो रास्ते आपके सामने आ गए. आपने will करी, आपने family trust बनाया, उसके थ्रू गया. और तीसरा ऑफ कोर्स रास्ता है ही जो सबसे ज्यादा पॉपुलर है. पॉपुलर कहना चाहिए, गलत पॉपुलर है, लेकिन interstate succession. About 80-90% people die interstate and put big difficulties to their successors. We go to the next. So what is a trust? Let us understand what is a trust. A trust is a relationship in which a person or an entity, the trustee holds the legal title to certain property, that is the trust property or the trust corpus, but it is bound by a fiduciary duty to exercise that legal control. How that fiduciary duty comes? That fiduciary duty comes through the trust deed and of course under the Indian Trust Act. For the benefit of one or more individual or organization, that is the beneficiary who holds the beneficial or equitable title, the trust is governed by the terms of the written trust agreement or the trust deed usually, and the local law of course has to read together. In our view, a written trust deed duly registered is definitely very necessary if you want to really do a effective really trust management. The entity, one or more individual, a partnership or a corporation that creates the trust is called the settler. So settler need not be only an individual. Sometimes a company can also administer a trust. Sometimes a partnership firm can administer a trust. An individual can administer a trust, or it can be another entity. As we said, that anybody who has legally empowered to execute contracts can also create a trust. We go to the next, please. Now, this is the broad typical structure of a trust, a standard trust. Of course, there could be many permutation combinations which one can see. Settler is the original owner of the assets and creator of the trust. He is the author. We call him author of the trust. We can call him settler of the trust. He is the owner of the assets, and he actually throws his assets into the hodgepodge of the trust. The trust is actually not a legal entity. It is, it is some kind of agreement which is created through a trust deed. A trust deed, of course, trust is created through a trust deed. Trust deed is executed by the settler. The settler can get it registered, and through that registered trust deed, he can appoint trustees. And trustees could be individual, trustees could be a trust company, trustees could be more than one individual also. And there can be beneficiaries which can be identified. The settler himself can be beneficiary, as I told you, primary beneficiary. The secondary beneficiary, ultimately beneficiaries, could be his wife and his children. Alternatively, the settler need not become a primary beneficiary. The primary beneficiary can be any person, either his wife or his children, or maybe even a third party, or maybe a group of people or a class of people. That depends on the wishes of the settler to whom he wants to actually, for whose benefit he wants to actually set up this. And these beneficiaries could be a determined number, could be a definite number, or could be an indefinite number also. It could be an indefinite number also. Trust asset. The trust assets are held in one or more accounts or the entities specified by the settler which are opened in the name of the generally what we do is, below the trust we create a investment company or a investment holding company where various assets are held. Although it is not mandatory, the trust can hold all kind of assets. It could be movable properties, it could be immovable properties, it could be anything which a trust can actually hold, and all the assets which the trust is supposed to hold are to be legally registered in the name of the trustees. The trustees, for the benefit of the beneficiaries, will be holding this. So ultimately, beneficial owner will be the beneficiaries. The trustees are only keeping it, only managing the assets. Primarily, as in terms of the trust deed, the trustees may be paid some remuneration, maybe with remuneration, maybe without remuneration. That depends on the relationship between the settler and the trustees, between the settler and the beneficiaries, and depending on the cause which is there. But normally, I would also like to add here that chartered accountant firms can also provide these services. It is permitted to act as a trustee for and on behalf of the client, and or maybe a corporate trustee you can set up who can actually provide these services, because clients are definitely finding a reliable trustee becomes a very, very difficult exercise, and that's how a large number of clients have started looking towards their chartered accountants to either have a trustee company or have individual trustees, or maybe a person selected by the chartered accountant or taken as trustees against a particular fee. You can always manage the trust assets in the name of the trust. We can go to the next, please. Private trusts used in succession planning are governed by Indian Trust Act 1882. The public charitable trusts are not governed by this law. That is very clear. There are different laws which govern the public charitable trust, but for Indian Trust Act 1882 is the law which is there for determining the private trust. So whatever you are doing, just read through the Indian Trust Act. It will give you good guidance, and also Indian Succession Act and Hindu Succession Law. So that will give you good guidance. And settler, trustee, and beneficiary. Settler is any person competent to contract. Trustee, any person competent to contract. There could be corporate trustee as trustees. There could be individual trustees. Now, protector oblique administrator, although has been an untested commodity in India, but based on international experience, our international experience in US, Europe, and various parts of the world, we have started, of course, this exercise of appointing a protector even within India. And of course, international trust, in any case, regularly we are appointing protector. Protector is the person who is the person of confidence of the settler, who protect the beneficiaries from the mistrust undertaken by the trustees, or sometimes there are a lot of approval powers which are given to the protector or the administrator by the settler through the trust deed, that the such and such decision can be taken with the trustees only with the consent of the protector. There could be a protector appointed by the trust deed, or alternatively how the protector will be changed, whether the beneficiaries can change the protector, whether the settler can change the protector. All those provisions can be there in the trust deed. Beneficiaries could be any person competent to hold property. देखिए यहाँ है not competent to contract, competent to hold property. So anybody can be beneficiary who is competent to hold property. Trustee holds property for the benefit of and not on behalf of beneficiary. देखिए बड़ी इंपॉर्टेंट बात है कि उनके बिहाफ पर होल्ड नहीं करता बेनिफिशियरी के. ट्रस्टी होल्ड्स इट ऑन हिज ओन बिहाफ, in his own name, but for the benefit of the beneficiaries. So there are rules against perpetuity, as I explained you already. You can revoke the trust if it is a irrevocable trust by the settler himself. At will he can revoke it. If it is not a revocable trust, then in terms of the trust deed it can be revoked, of course. But if in the terms of the trust deed the powers are with the settler, in that case it will become like a revocable trust. So, but sometimes the third parties are given powers to revoke the trust, including sometimes beneficiaries. So whenever there is no specific power given anywhere, then all the beneficiaries need to give their consent and the trust can be revoked if the trust deed is silent on this. The amendment to the trust, how a trust can be amended, trust deed can be amended, is generally provided in the trust deed. In case it is not provided in the trust deed, then with the consent of all the beneficiaries, the trust deed can be amended and the amendment can be registered with the consent of all the beneficiaries, whether primary, secondary, or ultimate, all the beneficiaries, or in the manner in which it is authorized by the trust deed. We can go to the next, please. The trust can be public trust, private trust, we have explained to you, specific trust or determinate trust of the trust, where the distribution of the benefits and the ownership of the asset is specific. It is clear whether 20% each, whether 30% each, or whether 20 to one, 30 to another, 40 to another, like that, or there is a discretion, is called discretionary trust, where trustees are given a discretion either on their own or with the consent of the protector to distribute the benefits of the trust in a discretionary manner as it is determined appropriate by the trustees, is called indeterminate trust or a discretionary trust. And of course, taxation aspect I have already explained to you. In this case, in case of discretionary trust, the assessment has to be done in the name of the discretionary trust itself. Whereas in case of a specific trust, there is an option which is available with the income tax officer to assess either the trust as an individual or assess the beneficiaries in the hands of the beneficiaries. But the overall tax liability doesn't go up. It is only a question of who pays the tax. Overall tax liability doesn't go by exercise of this option by the income tax officer. So you can also decide on your own and accordingly file necessary returns either in the names of the beneficiaries or in the name of the trust. But income tax officer will have a right to change your decision in case he feels that no, it has to be taxed in a particular manner. Then it will be done in that manner only. Revocation based. The trust could be revocable and irrevocable. That, of course, we have explained in detail. We go to the next, please. It's a simple trust where the assets are transferred and the trustees are actually supposed to transfer those assets to the beneficiaries at an appropriate point of time. These are not long time trusts, they are only for a short period, unless they arise out of protected litigation or when the beneficiaries are minor, then of course they become long term to that extent. Sometimes people say it will be passed on to the beneficiaries, all the assets will be distributed among the beneficiaries after all the beneficiaries become say 25 years of age, or maybe after their marriage, or 25 years, whichever is earlier or later. There are various kind of permutation combinations which are there. Constructive trust is imposed by law as an equitable remedy. It generally occurs due to some wrongdoing somebody has done, then he has to compensate. Of course, this due to fiduciary duties, and that is how certain properties are held in a trust. Resulting trust is a form of implied trust which occurs where a trust fails, wholly or in part, as a result of which the settler becomes entitled to the asset, is called the resulting trust. Go to the next, please. Discretionary and specific trust I have already explained. I will just give you a minute. You can just read through what is written so that you can structure your questions accordingly if you have any. Then we can go to the next once you have gone through. Another half minute. This is the most important decision you have to take. whether it will be discretionary trust or it will be specific trust. That is where a chartered accountant in practice who understand tax laws can be of very good help actually to decide as to what should be done. We can go to the next, please. These are, of course, some classification. I need not go through hybrid trust, express trust, implied trust. These are small things. Normal routine, just for your knowledge that there could be a fixed and discretionary trust is hybrid trust, partly fixed, partly discretionary. Express trust when it is settled deliberately, consciously to decide to create a trust. Sometimes the trust become implied because of the legal requirement. Or there is no express trust, but it is actually express trust. The basic requirements are not there, but it is implied that the person is holding asset in trust for the others, and out of the circumstances. For example, we have seen bailer baileys also, where the situation of a trust get created in the hand of the bailee. He has to actually ensure that he deal with the assets which are under his charge as a bailee, just like a trustees. Go to the next, please. Interview trust is a trust which is established by a person when he is living. A living trust is called interviewer's trust. आदमी जिंदा है जब उसने बनाया तो इंटरव्यू ट्रस्ट हो गया. टेस्टामेंटरी ट्रस्ट वो हुआ जो आपने अपनी विल एग्जीक्यूट की, उस विल से एक ट्रस्ट क्रिएट हुआ. There are a lot of tax planning involved through testamentary trust also. I think that one can actually examine various provisions of law which are there to actually take benefit of testamentary trust. Irrevocable trust is the one that will not come to an end until the terms of the trust have been fulfilled, or alternatively, the trust deed is silent, it says irrevocable, then all the beneficiaries, as I told you, as per law, 100% beneficiaries giving their consent, the trust can be revoked. Revocable trust, a trust of this kind can be revoked, cancelled by its settler at any time. That's very clear. We can go to the next. Now, how trust can act as a tool for succession planning, there are different steps. Defining trust lineage is important in order for trust to continue even after the demise of the original trustee. Step 2, delegation of authority and decision-making metrics is defined. Policy for distribution of corpus and income of the trust is determined. Providing veto powers to identify trustees for specific decisions. Safeguarding the interest of the specific family members, for instance, a spouse, you can actually really take care. Specific policies regarding the discipline and behavior of the next generation can also be determined in the trust deed. देखिए सारी चीजें आप कर सकते हैं, नॉट ओनली प्रॉपर्टी दे रहे हैं और उनके बिहेवियर को भी वॉच कर रहे हैं. कई बार आप कहते हैं कि भाई ओके सेकेंडरी बेनिफिशियरी माय सन एंड माय डॉटर इन लॉ विल गेट 75% 25% share of my property, but you put a restriction there. Suppose my son dies, after his death it is normal course will go to my daughter-in-law, but suppose daughter-in-law get into a marital relationship after the death of my son, then of course nothing will go to her and everything will go to ultimate beneficiary, that is the children. So like that, these kind of provisions can be given in the trust. The beneficiary waterfall can be decided very, very clearly, categorically. We can go to the next, please. अब देखिए ये पूरा चार्ट है जो बताता है प्राइवेट फैमिली ट्रस्ट में क्या क्या फ्लेक्सिबिलिटी है फॉर इफेक्टिव कंट्रोल एंड मैनेजमेंट एंड फैसिलिटेट स्मूदर ट्रांसफर ऑफ वेल्थ over generation, one generation to another, another to another. It is important to further amplify given anticipated reintroduction of inheritance tax. देखिए इनहेरिटेंस टैक्स आने की संभावना लग रही थी, अभी तो थोड़ी सी कम लग रही है आज की डेट में, पर फिर भी कभी भी आ सकता है. तो देयर कुड बी अ पॉसिबल इंसुलेशन दैट ए प्राइवेट ट्रस्ट में एक्सटेंड अगेंस्ट ए विल वेयर एक्सपोजर इज सर्टेन. बिकॉज अगर विल होगी तो डेफिनेटली इनहेरिटेंस टैक्स लगेगा ही लगेगा, पर हो सकता है ट्रस्ट के केस में ना लगे. व्हेन वी यूज द वर्ड हो सकता है, so it depends on how the law is drafted. If the law also covered inheritance through trust structure, then you can't really do anything. But normally we feel once a trust is created, a private trust is created, and you already transferred the asset to the trust structure, then normally there should not be any reason in case of death of the settler, because the trust is irrevocable. It will be difficult for anybody to really get it taxed as far as inheritance tax is concerned. Now if we see, you can use the benefit of a trust structure in maintaining family harmony, clear segregation of control and ownership. Then forehand planning आपने कर लिया advance में for contingencies. You can preserve the wealth and use the intrinsic value of a business. You can have, of course, asset protection mechanism can be, of course, provided there. Regulation of third parties entity into a family business can also be managed through the trust. You can, of course, restrict on carrying out competing business by the beneficiaries. You can also amend the trust deed as per the trust deed, and accordingly, even the beneficiaries can be undergone a change. They can be changed. There can be modification of beneficiaries. There can be change in the waterfall mechanism of the trust deed if the trust deed of the trust if the trust deed is so authorized. So, not there. Of course, the probate process will not be involved. It is possible to insulate against inheritance tax, and also it is possible to also, most importantly, you can also insulate it from your personal guarantees. There is a ring fencing which is done. Although there is a debate which is going on in the profession whether it should be determinate trust or indeterminate trust. In our well-considered legal opinion, it is better to create a specific trust, a determinate trust, and even then your properties will be ring-fenced from sundry creditors, from secured creditors, and various other creditors. It will be ring-fenced, where whatever may happen, the properties in a trust, if they've been transferred without any fraudulent preference, as defined in the law, insolvency law, if it is done without fraudulent preference, then of course nobody can really touch it. And fraudulent preference law, maximum it works for 1 year under presidency, and although under now the new rules under insolvency and bankruptcy code, the rules are in the process of finally getting decided. We can go to the next, please. The benefit is that the trust comes into effect during the lifetime of the settler. Perpetuity is prohibited. No process involved in settling a trust. It enables provision of financial security. Segregate ownership and management possible under the trust. Trust applied for succession planning of promoters of listed companies. Of course, you can have a flexibility of common control over assets possible under trust. We go to the next slide. I think we have to leave some time for the questions also. That's why I'm hurrying it up. A private trust may be created by trust deed while settler is alive or by will. Private trusts are governed by provisions of Indian Trust Act. Just a repeat, it has one or more particular individuals persons as beneficiaries. Where immovable properties are worth more than ₹100 are transferred, trust will not be operated unless it is registered. So, if a immovable property is involved of more than ₹100, then registration of a trust is necessary, mandatory. Trust created by will does not require any stamp duty payment. Private trusts are void for perpetuity. We go to the next, please. There are two types of trust. Of course, we have already dealt with registration of trust. Private family trust, of course, could be is normally an association of person, but if it is discretionary trust, then it is taxed as AOP. If it is not discretionary trust, then it is taxed as an individually in the hands of the respective beneficiaries. We go to the next, please. The registration for a trust, whether it in relation to movable property or immovable property, is optional but always desirable. I feel immovable properties trust has to be registered. It will become illegal in my view. Immovable property, of course, you can have even a unregistered trust deed. There are certain lawyers who are getting. Pardon, sir? There are certain people who are actually creating unregistered trust governing immovable properties also. In our view, a lot of issues. The registration of will with sub-registrar is very important to restrict any dispute about the validity of its existence. If it is coming through the will, a registered trust deed has certain advantages. It becomes an official document which carries support and force of law. It effectuates transmission of possession. A conveyance of trust proper to trustees under registered deed is generally not open to challenge. So then nobody can really challenge it. We can go to the next slide, please. Chawla ji, we are just towards the end, and I think we'll be taking questions. These trusts are registered under sub-registrar as per the area of registered office. You can go to your area sub-registrar, and of course, you need a settler who creates the trust. You need trustees also to go there, minimum 2 trustees who will look after the trust. And of course, you need to decide what is the initial corpus fund of the trust property. You can initially start the trust only by 10,000 rupees or 1 lakh rupees, or maybe a small sum, and can later on you can keep on contributing more and more properties to the trust. That is the process generally people follow. They create a trust with a small money, open a bank account, and then later on keep on adding more and more property by signing contribution deed. That is what is called. You execute contribution deed. In case it is contributing a immovable property, then the contribution deed should be registered to be effective. You can go to the next, please. 2 copies of the trustee, duly signed, photos of settler and trustees, address proof of registered office with NOC, address proof of settler and trustees. These are all required witnesses. All of the procedure are same as you purchase the property for the transfer. These are certain things which will be required in the sub-registrar office. We can go to the next, please. I think SEBI takeover code, etc. we can leave. I think, of course, regulation 11 exemption is required in case of trust structure. This we can leave. I think because we like to deal with international trust for a while. I think I like to just touch upon the international trust. The objective for all individuals, regardless of what country you reside in, is to create an international planning structure outside of their home country. Wealth is created, owned, invested in a trust structure. No income tax, wealth tax on beneficiaries, settler can be planned properly if you plan this structure properly. You can control the money without paying any tax in your home country and without being taxed for wealth also. But it has to be done very carefully which country you take, because ultimately your trust properties will be owned in that particular. So the local trust laws, you have to actually definitely consult a local trust lawyer as well as local property law you need to really see. And certain countries have inheritance tax very severely. More importantly, like US and European various countries have inheritance tax. And in case beneficiaries are resident beneficiaries in those countries, then of course inheritance tax will still be levied, even in case of trust structure. So one has to plan it properly, especially when you're planning for an Indian or a non-resident Indian or a returning non-resident Indian. These structures can become very, 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 very useful, where there is a trust structure above, below which you can have a investment company holding all properties. All the income are earned in the company, and no income is transferred till the time the income are transferred to the trustees, to the trust or to the beneficiaries. There is no tax which arises to the beneficiaries, even if the beneficiaries are in India. And of course, even FEMA regulations also can be dealt with accordingly. That depends on what is the source of money from which the trust is created. We can go to the next, please. Objective, of course, is flexibility and to meet the need of money confidentiality without regular compliance, and of course, inheritance plan, and create wealth outside India or maybe outside your home jurisdiction. Go to the next, please. Trust is created to own international structure. Wealth is created, owned in the trust structure, invested by the trust. No income in the hands of the beneficiaries. Trustees are directed by the settler. Trust could be revocable or could be irrevocable. Trustees and trust both are outside India. Formal agreement is done with the trustees. We go to the next. I think case studies का time नहीं है अपने पास. क्यों चावला साहब case study का time नहीं है ना?
Sir, we also have questions. I have forwarded to
we'll
Ananda
take
ma'am.
questions now. So I think we'll stop here.
थोड़ा क्वेश्चन आंसर ले लीजिए सर बस.
Go to the last slide. Okay. I think we can take questions. So who will ask questions? Shrutika, you are going to ask, or Ananya is going to ask?
Shrutika, please take questions.
So sir is also there, Chitle Sahab is also there, and I think we have Chawla Sahab also with us.
Yes, sir.
Yes, sir.
Sir, just a second. Am I audible, sir?
Yes, you are fully audible. I think I request everybody can actually switch on their videos so that Ananya and Kilesh, both of you can also come on the screen.
Okay. Sir,
Yes, yes.
if the claimant become a citizen of an unfriendly country, then how the rights will be affected?
If the claimant becomes a citizen of a unfriendly
country, yeah, then how the rights will be affected?
You see, the rights will, of course, definitely be affected. Suppose you become citizen of China, for example, or you become, there are, countries which are actually blacklisted by the international bodies. then of course transferring money to those countries will not be possible. But even if suppose your son, your daughter has become citizen of a unfriendly country, but he is son or daughter of a local Hindu, then of course inheritance will happen. Subject to, of course, the how he will really exercise it in India. If the country is unfriendly, means suppose there is a war with that country, only then the question will really arise. But in otherwise, suppose even if you are a Chinese national or you are a national of Pakistan, even there is an inheritance in India, I don't think there is any major issue even in FEMA to really take hold of that property, sell that property. But of course, transferring that money outside India will be subject to FEMA law. It depends on the nature of the property, etc. But the best FEMA law permit all inheritance cases. The transfer of money outside India up to one house, it is permitted unlimitedly. Otherwise, $1 million scheme every year can be taken out from India. I think under that, even if it is an unfriendly country, it will be possible for you to really take money out if the inheritance has gone to a citizen of unfriendly country, provided it has gone to him through a will. There could be some difficulties in terms of those country may refuse to really take the money. Then on the instruction of the person concerned, it can go to third country if that FEMA law permit there. I think it depends on the lot of planning. We can go to the next question, please.
I think if
Is
I
there
may
a
supplement,
difference
Shrutika, hold on.
Supplement this, yes, sir.
Yeah. No, see, from your lecture, what I understand, as far as succession is concerned, whether it's from friendly country, unfriendly country, it will not affect. Succession will be governed by the law to which he is subject. Only repatriation would be the issue, as you have rightly explained.
Yes.
Succession will have no bearing on to which country he belongs or he is citizen of.
Sir, मैंने एक और ये भी नहीं handle किया. For example, the children have adopted another religion. They have become Muslim or Christian. Even then, that it doesn't affect. The succession will still happen as per Hindu Succession Act if the person who is dying is a Hindu.
Yeah, so as per personal law, succession will be governed. Repatriation may create some issue if at all we are not allowing repatriation.
Chawla sir, you want to supplement something or
So
Akhilesh?
if I may complement,
So shall I move to next
Comment, sir.
question?
Adina wants to supplement.
so with respect to the point where you stated, sir, that if the person has changed their religion, the child has changed their religion, they will still be entitled to their parents' assets. However, any children, that particular individual who's converted to another religion, their children will not be entitled to any benefits or assets or anything from the grandparents.
We can go to the next question, Shrutika ji.
Is there a difference in registered or unregistered will and their implications?
I think that we have already explained it by our slides very clearly. Will, whether it is registered or it is unregistered, both wills are fully operable. The only thing in case of an unregistered will, to establish the existence of that will, its genuinity, whether the same person who is executing, the same person signed, whether he was sound mind, whether he was a proper health, whether he does it with free will, all that you will have to establish with the help of the witnesses in that case.
Okay. So if an ancestral property is received by a male and then divided by gift deed amongst the ascendants of male, will the property retain its character as ancestral property or self-acquired in the hands of the ascendants?
Yeah, I think this first we need to determine the property, the manner in which it is coming in the hand of this male. If this property is coming from his father or his grandfather or his great-grandfather, in that case he received this as an ancestral property. Please appreciate this. Unless father gives in this property through a document, through a testamentary document. अगर फादर से प्रॉपर्टी विल के द्वारा या फिर गिफ्ट डीड के द्वारा आई है, then it becomes a self-acquired property. Otherwise, it becomes an ancestral property and his children will be entitled to object for alienation.
Okay. Can you please explain compulsory sale of property through court process to maintain the minor children of Hindu family?
I think ultimately, suppose there are minor children which are there, which are successor. and there is no proper succession plan which has been done, but there are properties which have been inherited by the minor, I think nobody has been appointed either through a will or otherwise as a guardian. In that case, somebody can approach, any relative can approach the court. The court, of course, can decide whether it is necessary to actually sell the property. Then I think the court can take a decision. They will have to appoint an administrator. The court will appoint an administrator, and the administrator will sell that property as per the orders of the court, and then will also keep that property in trust for and on behalf of the minor, and will administer as per the directions of the court. This is a regular process which is happening in case of minors, as well as sometimes people may become insane or they become incapacitated to contract. In all such cases, the court are there to help and support the process.
If a property is owned jointly by the individual and the joint family of the individual consisting of himself, wife, son, how the property will devolve after the death of the individual without will left by the individual?
Your question is not very clear to me. It's a very complicated question, completely drafted. You're saying it is jointly by him as well as his family. So there are two parts, that is 50% he is owning and 50% family is owning? Or when you say he and family is owning, does it really mean there is a family holding?
But it's written without will left by the individual.
Please repeat the question.
If a property is owned jointly by the individual and the joint family of the individual consisting of self, wife, and son, how the property will devolve after the death of the individual without will left by the individual?
Okay, I think I'll take this question in a little different manner because the language is very complicated.
Shall I respond? See,
Yes, sir,
as far
please.
as the property is concerned, let us assume that there is 50-50% ratio. So if a person expires, 50% will go as per Hindu succession law if he is Hindu, or his personal law. As far as HUF is concerned, there will be notional partition, and whatever share comes to his hand or under his control, that will be going as per interstate succession. Balance will remain with the HUF. That is, I think.
Yes, very right. I think that is completely right, sir. Bilkul correct hai. And of course, there will be assumption as if there is a partition of that HUF just immediately before death. How it will go, accordingly it will be divided as per the 2005 law.
A registered will mentioning the share of assets of beneficiary may be a base document for succession certificate provided by a tehsildar, and further beneficiary may be used that for the resale of the assets.
आप सब बोलिए, आवाज आपकी जो है ना, साउंड जो है ना जरा इको कर रही है. Difficult to understand what you're saying.
Okay, our registered will.
Voice is also there.
Sir, is it clear?
थोड़ा जमा के बोलिए धीरे धीरे, ताकि सारे सुनने वाले भी सुन सकें और हम लोग भी सब सुन सकें आपकी बात को, प्लीज.
A registered will mentioning the share of A registered will mentioning the share of assets of beneficiary may be a base document for succession certificate provided by tehsildar. And further beneficiary may be used for the resale of the assets. The question mark is.
You see, ultimately the will cannot decide who are the successors. Will not decide who will succeed the particular assets. The succession certificate is of course a different aspect. Succession certificate based on will, you can take a succession certificate. That is what you are saying. If I have understood your question, without beside a probate, whether through succession certificate properties can be transferred. Yes, in certain states it is possible. In many states, probate is mandatory. I think Akhilesh, why don't you explain? We have been doing it regularly through succession certificate also. Akhilesh, please explain.
So to me, the question is not very clear, sir.
I know, but to you, question is not very clear.
Yeah.
Next question.
I think maybe Chitale sahab, can you elaborate the question?
Next question. It's not very clear.
Sir, we can, if it is not clear, we can move to the next question, sir.
We can go to the next question. Okay.
Yeah. Can a person bequest the complete HUF, not just his portion?
No, he cannot. He cannot. Only his portion is entitled to bequeath.
Okay. What are the relief available to the successor when the property is given on reverse mortgage and loan is taken from individual lender?
When property is given on reverse mortgage and loan is taken from individual lender and there is a succession which is happening, then the only alternative with the successors is to pay off the debt or the charge and then distribute the property in accordance with the will or the interstate succession. Please obtain a probate or a court order or maybe a succession certificate depending on which state you are in, and accordingly transfer that property to the heirs. Sometimes based on registered will, the legal heirs may be able to directly sell the property to third parties, and there are several registrars who permit sale of properties based on registered will by the legal heirs as per the registered will.
Bhai, just excuse me, I have some another meeting at 7 o'clock, so I will exit now.
Sir,
Okay,
what
sir.
can I do is I can send the questions to you. I can mail to you. Hello?
I think the Chitale Sahab has left. Chawla Sahab, sir, you can decide, should we continue for some more questions?
Yeah, I don't mind. If Shrutika, you can take if some questions are there, no issue.
We can please take some questions.
I can continue for next 5-10 minutes.
You just give me 1 minute. No, this phone is actually troubling me. Exactly like 7. Just hold on for a minute. In the meanwhile,
Yeah.
Ananya, please take the questions, huh?
Yes, sir.
Yeah, one is it mandatory to get registered the partition deed of HUF in case of immovable property included in assets held by HUF, and in case only movable assets are held by HUF?
It is recommended to get the partition deed registered so as to avoid any future complexities in this regard, because when it comes to a matter of partition, and especially wherever money is involved, irrespective of being movable or immovable, and if a partition is being undertaken, the document, if it's registered, it shows that the parties have consented to it. Then the chances of any individual backing out at the last minute will be very less.
Okay. Why is it so that Hindu Succession Act 1956 is applicable to a person without a will, and Hindu Succession Act 1925 is applicable to a person with a will? What are the difference?
There is actually a slight confusion from the person who's asked the question. Hindu Succession Act 1956 and Hindu Succession Act 2005 is applicable to an individual who's died without a will. A Hindu who's died after making a will, they are governed under the Indian Succession Act 1925.
Okay.
Yeah.
In HUF, can daughter who is getting share does not want to take that share from HUF? Can she give HUF registered document for not demanding share in future from HUF? And can it is valid in future litigation while there is division of property?
This is a difficult question. Ananya, this is a very difficult question. That trial, a lot of people will do that. When the daughter is unmarried, they can really get a document executed from her, sometime by the brother, sometime by the father, that you will not claim share in the HUF property. All such written declarations can be later on challenged, not only by her, even by her children. Please appreciate this, because she is not alone who is entitled. Her children are also entitled. So as soon as she has some children, the children can also challenge, or she can also say, it was taken by, this consent was taken under duress. So when her father dies, that will be the right time to really decide. If at that time she writes, no, I don't need anything, then of course it is okay. Then it is with her sweet will, she don't need anything. But that relinquishment, we call it relinquishment, has to be done at the opportune time. You can't do relinquishment today for something which is going to happen after 20 years or after 10 years. It will become very, very confusing and very, very, you can say, litigative.
A Hindu lady dies without making a will. Whether the husband and children, including married daughter, can divide the deceased lady's assets in unequal ratio by mutual consent, what will be the consequence in recipient's hand?
That can be done without any difficulty. If all the legal heirs agree, then it can go in different ratios depending on, I think, based on the family settlement, they can execute a family settlement document and accordingly transfer it. There is no issue at all.
Okay. Is it necessary to distribute assets in equally to all members of
Before you go further, I think Ananya has just shared me, I think yesterday only, a judgment has come, a very, very important judgment has come from the Honorable Supreme Court. Where Honorable Supreme Court hai na?
Sir, it's a Delhi High Court judgment.
The Delhi High Court judgment. So the Delhi High Court judgment, what it is saying is that in case there is a family settlement, suppose there is a dispute between the family, and then there is a family settlement, and based on that family settlement, the properties are transferred to the transferees. In that case, there is no need to pay any stamp duty. I think, of course, the procedure, of course, in such cases normally has to be followed is that the dispute is there before the court of law, and then before the court of law, then settlement is done before the court. That settlement is filed with the court. There is a court decree. There is a court settlement decree, and then it become without any dispute. No stamp duty will be payable in such case. So transfer of property to respective beneficiaries as per the family settlement. The Delhi High Court judgment which is there. I think citation, if you have readily, then you can tell. But this is very important.
So most of the questions are being covered.
If there are any more questions, people can write to you or maybe even write to me personally. vinodjainca@gmail.com. vinodjainca@gmail.com they can write. We'll be too happy to actually reply these questions. And always we are there to serve the profession. There's no problem. And I think we now let Mr. Chawla actually guide us.
No guide, sir. I am your very junior, sir. So thank you very much, respected Shri Vinod Jainji, our past Central Council member and director in various companies, and so having vast experience in this succession planning. You are the master in this subject, sir. So I am thankful to you for sparing your valuable time to guide our members. And I am also thankful to my direct tax committee, especially the chairman, Chitle sir, and Shrutika madam, our secretary of this committee, and all your colleagues who has helped for this webinar. And I am also thankful to all the members attending this webinar. So with this, thank you all. And friends, as suggested by Shri Vinod Jainji, you can write your queries either to the direct tax committee. We will send him your queries, or you can directly send him via email. So Jain Sahab, I will again request you to please tell your email ID.
Sir, my email ID is Vinod Jain, CA, VINOD Jain, CA, all one word, there is no stop any between, no dot, vinodjainca@gmail.com, or alternatively DTC email ID, sir, you can announce, and we'll pass on, sir, this PowerPoint presentation to the committee. And
sure,
if you want, you can please announce where you propose to host it so that people can download it for their benefit.
Shrutika ma'am, you can
host it. Yes, sir, I'll host it on ICI TV.
Okay.
ICI
Yeah,
TV.
So members who are requested, if you want to download, then you can download from our ICI TV. And with this, I am thankful to all. Thank you very much.
Thank you.
Thank you, sir.